All right, the Committee on Elections will come to order, and clerk, please call the roll.
Chair Lovenberg,
Here.
Vice Chair Goldman,
Here.
Representative Reynolds,
Here.
Representative Fallon, Representative Israel, Representative Dade Phelan, Representative Schofield.
Here.
We have four.
Okay, everyone's here, and thank y'all for making it. I know lots of things are going on, so and appreciate y'all coming in town, everyone that's here to testify. And as I said yesterday, the interim charges are assigned by the Speaker with input from committee members and other members. And so what we're going to do is during the interim, we do invited testimony. But anyone who is here as an observer or who wants to put in as a witness, you can put in a witness affirmation. But the testimony, because we have no actual legislation, is basically informational and designed to help us, decide if we need legislation, what kind of legislation during the session. So that's why we do the invited testimony. So with that, we are going to look at charge number 1, which is examining the petition process for addressing local ordinances, the time necessary to prepare a petition, the collection of signatures, and the enforcement of local standards required for a petition to be valid, and to make necessary recommendations to clarify the petition process, if needed, to ensure accountability. And so with that, I've broken it down to panels, and the first panel, I would like to introduce Bill Longley, the Legislative Counsel for Texas Municipal League, and Paige Sims, the City Attorney for the City of Plano. So if y'all would like to come up, and I want to make sure that everyone has filled out your witness testimony form, and if you need any help, Suzanne can help you. And if you don't mind introducing yourself again, just for the mic here, I would appreciate it.
My name is Paige Mims, and I'm the City Attorney for the City of Plano, Texas.
And I'm Bill Longley, Legislative Counsel for the Texas Municipal League. I don't know if
Okay.
Does it matter who starts? Or?
It makes no difference to me, and if you want to do ladies first,
Okay,
that
thank you.
would be great.
Good morning, Madam Chair and committee members, and thank you for inviting us here today to talk about the citizen petition process. The City of Plano respects the citizens' ability to participate in the initiative and referendum process, and we realize that that is important to city government. Plano has a long history of successful citizen petition participation, and the Plano City Council has been very responsive to the endeavors of our citizens in that area. I've attached to my comments that I submitted to you a chronology of recent petitions that have been submitted in Plano and the outcomes. And in the past quarter century, Plano has had 7 petitions submitted by citizens. 4 elections have been called on those citizen petitions. The council repealed 1 resolution in response to that petition drive. And in 2004, the council proactively implemented a senior tax freeze when the citizens had initiated a petition process, and they did that prior to the petitions being turned in. However, more recently, you're probably more familiar with several of the petitions that failed to be moved forward to City Council. They were legally insufficient, and those were regarding the Plano Equal Rights Ordinance and the Plano Tomorrow Plan, which is the city's comprehensive land use plan that is part of our zoning scheme. So, as I said, those were legally insufficient petitions, and those were for different reasons. The Equal Rights Ordinance petition had legal deficiencies both in the form and execution of the petition based on state law requirements and city charter requirements. The Plano Tomorrow Plan petition was outside the scope of subject matter that can be placed on a ballot pursuant to referendum, and that's as dictated by the Texas Supreme Courts and other courts in our state because it requires methodological data. We worked on that for 10 years, had over 4,000 citizen input process, requires public hearing, and it's just not one of those things that can be easily put on a ballot for a vote. In both of these cases, the city followed the law, and we also were very transparent and helped to facilitate this process for our citizens. So on the Plano Equal Rights Ordinance, I'll give you an example of that. The ordinance was passed by council on December 8th, 2014. I think due to the Christmas holidays, there may have been some delay in circulating the petitions. We first noticed petitions coming up for citizens to circulate on websites and through mass emails at the end of December. Within a few days of seeing those petitions, the staff, we noticed that there were mistakes on those petitions, and we were aware of what was going on in Houston, Texas. We did not want to have those issues. We wanted to help facilitate. We did not want to have disputes over the signatures. And so one of our deputy city managers sent an email to the 4 contact emails that were on these websites or mass emails. And I have a copy of that email in the comments I submitted, and we specifically gave them links to the law and to the Secretary of State's website that helps explain some of those laws. And we also specifically pointed out that they were missing the information for having a column for the write down the county, because we're a city that's in 2 counties and the election code says you have to write your county. So we said you are missing that information. And it looked like that they were on their forms going to later insert voter certification numbers, because most people don't know that when they're signing a form, and that creates a lot of potential for human error. So we let them know you can also use date of birth, because everyone knows when they're born. We did not hear a response from the petition circulators in subsequent to that email, but we did see their form change. They also had misinformation on the header of the form about what the ordinance was really about. So they were misrepresenting information about the ordinance, and they did remove that information, but they didn't fix their form as we had tried to help them to do. So we tried to give them a roadmap. They didn't follow it. We will respect any changes in the law that the legislature recommends, but if people still have to execute forms correctly. Just because petitioners are denied being presented to council doesn't mean they're not being treated fairly. The legislature, the citizens of the cities through the city charters, and the courts have told us there are rules you have to follow when you bring forward petitions. And I don't think that anyone would indicate that the city should ignore those rules, and we're not. Also on the Plano Tomorrow Plan petition, we knew that they were thinking of circulating a petition and that there was a group of people that were not happy about it.
Excuse me, Chair, I'd like to recognize Representative Fallon. Thank you.
At a public meeting where some of the petition circulators were present, we told them, because we know it takes a lot of time and effort to circulate petitions, we're not trying to impede you from doing that, but we want you to know what the city's legal position is before you take all that time and effort. If you turn those petitions in, we do not believe that that is subject to referendum, and they will not be processed. And they disagreed with us and circulated the petitions anyway, which is fine. That is their right to do that. We did answer questions. I've spoke with Ms. Epstein, who's here today personally, and exchanged emails with Mr. Dillevue about the legal position and also about just how to execute their petitions, because they didn't want to end up in the same position as the Equal Rights Ordinance. They had a lot of questions about the forms, and we answered those. But the petitions were not processed like we told them up front that they would not be. We did have a lot of problems in both cases with misrepresentations by the circulators to citizens, and I know I heard some discussion at the Senate committee hearing that there's concern about cities and ballot language. I think that if that's addressed, that it should be addressed both ways, because we had lots of citizens calling confused when they realized what the ordinance or the meaning said. They wanted to know how to get their names in certain cases off of the petitions, and once those are turned in, that is not possible. But we think the system's working. We've had many successful petitions. The rules are easy to follow. Our citizens have been largely successful in that. If the legislature proposes new rules, we will certainly continue to follow those rules and require petition circulators to follow those rules, and we will always respect the right of our citizens to participate in democracy and help them achieve that goal when we can.
And you know, they're citizens. It's the ultimate local control. So, but they're not lawyers. They're not, you know, legislators where, you know, they're used to seeing all the technicalities. And I think, you know, when they work to get so many names and it's tossed out because of a technicality, you can understand the frustration.
I understand the frustration, but we did, the one thing that invalidated every signature on the Equal Rights Ordinance petition was that they failed to have a county. That's a state law, so
Right.
we would
But-
not ignore that. But they did have other problems with that petition, and we did try to communicate to them up front. We did not, we wanted them to be successful. If you look at our email, we communicated about 20 plus days ahead of time to them.
But it's all in a 30-day time period.
Well, it was actually ended up being about 45 days because it's once the ordinance is published, and we have to publish twice within 10 days. And then there was a Martin Luther King Jr. holiday, so we you know, it was extended by a day because of that. So it was about 45 days. In both the cases, there was not a problem with the quantity of signatures. One was the execution, which we gave them a roadmap how to do. And then the second one was just an issue that the subject matter is precluded from being on the ballot. So it doesn't, you know, the signature
When they
counting
turned
doesn't
it
matter.
in and you saw it, how many days were left to fix it? When were they made aware that there was a
We
problem?
sent them an email on December 30th, 2014, and it was due on January 20th, 2015. But we did it as soon as we could after we saw the petition forms.
Madam Chair.
Representative Israel.
Thank you, Madam Chair. Ms. Mims, thanks for making the trip up here. I appreciate your comments, and I'm thinking of, I have a friend who's a consultant who does these kinds of petition gathering on, of all things, liquor laws. And so he's a consultant, he's a professional, he knows the drill, he knows what to do. But it seems to me like for those who don't have a professional consultant and this is their first time, it can be overwhelming. Do you have a section on your city's website that identifies you as a point of contact? Because it seems to me like what you're also painting is a problem that I find all the time, which is simply communicate, talk to us, let us know what you're trying to achieve, and we will help you we'll guide you through this process. Do you think that's the case in this situation, and do you think that the city had enough information publicly out there to help someone make early contact so that they weren't doing things incorrectly and therefore losing time?
Right. We are very responsive when citizens call in. Our city secretary is very helpful in providing information. My office is always available to talk to citizens about these issues. And we did try to proactively, when we noticed mistakes on the petition, reach out to the Equal Rights Ordinance circulators and let them know, you have mistakes. These are specifically your mistakes. We don't want you to fail in this endeavor. We don't want to have problems with validity of signatures.
So there was nothing subversive about it. It was just simply, in hindsight, I think if there had been more early communication about the process, it might not have had the outcome that they wanted, but they would have at least met the criteria that was legally called for.
We are available, and we will do that. We're happy to provide forms. We're happy to provide copies of forms where people have done successful drives. We, I think, are very accessible as a city and very proactive in interacting with our citizens.
Okay, well, thank you. I also feel compelled as a member of the LGBT community to say thank you, because I think the ordinance that you had in place reflected very well on your city. So thanks for doing your job.
The credit goes to the city council, but thank you.
I think we have Rep. Fallon and then Schofield.
Thank you. Madam Chairman. Having you used to represent Plano, yes?
I still do.
You oh, you do? I did not know that.
Yes,
All right,
they took
thank you.
Rockwall from me,
Sorry.
not Plano.
I got you. Okay. I have the honor to represent a little teeny portion of Plano, the Denton County side, slightly better side, but anyhow, be that as it may. So just to be proactive and kind of continuing with what Representative Israel said about being proactive. So the question, you don't have anything currently on the website right now? If I want to start a petition, I'm a Plano
If I
resident.
may intercept, what we're trying to do here is figure out, you know, what we can do to make the process that you have in place, you know, easier for the citizens. Is there something we can do? And I think that's what you're.
It would be because, piggybacking on the chairman's point, this is the one thing, you know, citizens, like, you can't get more organic and grassroots than a petition drive. And regardless of the content, whether we agree with it or we don't, I want the citizens to be able, even if it was when I was on the city council in Frisco, to recall me. I want them to be able to do that. If they can't, if they want to, and there's enough people that want to sign that form, then they should be able to if the city charter allows it. So that's where my passion lies, in making sure that we make it as easy as possible. So some of the questions, you know, and because maybe we want to draft legislation as well, and having you here, just wanted to see what you thought. I love the idea of something on your website, a little button and a drawdown where you want to start a petition. Here's a good thing to try. So currently, right now on your website, that does not.
I don't believe we do, but I will follow up if I'm correct about that. I don't believe we do. We are very accessible, and it wouldn't be a problem for Plano to provide a form.
Well, that's the city council's job to really direct staff to do that, because I don't think that, I'm guessing Frisco and most cities probably don't have that, but that wouldn't be a good idea. That's something that I don't know if we want to compel them to do it, but it would be nice to do it. And being that I do represent a bit of Plano, maybe, you know, we can talk to the city councils of the cities that we represent, because I'm thinking about, in a perfect world, the drop-down menu, an example of a successful petition done correctly, because that's something that really helped go on. And then maybe even a troubleshooting form, the things that you have seen or your staff that, hey, we rejected past petitions because of these
Frequently
things,
asked
to look it up,
questions.
you know, a landmine thing, and then maybe an FAQ as well. That would be, granted, proactive and above and beyond, but that's what we're all in the business of trying to do, is being above and beyond.
And may I just say,
Yeah,
before
please.
this most recent, with these most recent petitions, we weren't aware that there was an issue like that, because everyone prior to that had been successful in executing their petitions. So it seemed, you know, like the system was working. And so we have tried to provide information, and also to the Plano Tomorrow Plain petition circulators. They had a lot of specific questions because they knew about the other form that didn't pass, and we, you know, I think we were very active in providing that information. But I do think what you're saying, you know, a form, a link, yes, we can always provide more information.
Is there room for improvement?
Yeah, because I think if you have that and a petition comes in and it's not valid, that really doesn't reflect on the city attorney or the city at all. It really reflects on the people that are gathering it. But when it doesn't exist, regardless, again, on this side, like whatever, obviously if it's going to be that organic and it's going to be a hot topic, whatever it is, whether it's a recall of somebody, an ordinance such as the one we were talking about now. And what we don't want is the conspiracy theory, the thing that, oh, it was gamed against us, we were pushing a boulder uphill the whole time, because we want, everybody up here wants citizens to get involved more. The more they are involved, the better our communities are going to be. And to have them that involved and then get rejected on, again, like a technicality or whatever you want to say, I know. It's
State law.
Oh, yeah.
Well, and then
No one's disagreeing with
yeah,
that.
and, you know, sometimes laws, you know, technicalities are the state laws. But and then I'm thinking on our end, if there's something we can do, err on the side of intent and give more flexibility and discretion, and we have to think about that and talk to some people that are smarter than ourselves. But thank you for being here. I appreciate
Yes,
making the trip.
thank you. I appreciate you allowing
Thank you, Madam
me.
Chair.
Any other, oh, no? Okay. You got it, okay.
All right. Again, for the record, my name's Bill Longley with the Texas Municipal League. Happy to be here. Thank you for the invite, Madam
Thank you for
Chair and
coming.
members of the committee. Hopefully I can add something to the dialogue here. I'm glad Paige is here to be able to talk in specifics about how this plays out in Plano and in individual cities. I want to try to take a step back and discuss it from sort of give a bird's eye view of the initiative and referendum process as it exists in Texas. initiative and referendum in Texas is unique to Texas cities. As y'all are well aware, there's no INR at the state level. Some states have done that. Texas has not done that. And generally speaking, you don't have that at other levels of local government. In the state of Texas, there are 1,215 incorporated cities. I think that's right. It's somewhere around 1,215. And of that total, there are 825 general law cities and 390 home rule cities. Just to give you a very basic overview of that, I know most of you are very familiar with the difference, but general law city is a city that's typically under 5,000 that has not adopted a city charter and therefore can only do what state law authorizes those cities to do. A home rule city, on the other hand, is a city that at least at some point in the past went over 5,000 in population, and the voters put into place a city charter to govern how that city operates, and the city can essentially do anything that's authorized by the charter unless state law specifically prohibits that home rule city from doing something. So with that framework in mind, you have home rule cities only who in their charter have put in initiative and referendum procedures. We did a home rule charter survey a few years back, and by our count, about 93% of home rule cities have some form of initiative and
Okay, so
referendum.
not every home rule city has the.
Correct.
Okay.
Correct. The vast majority does, but
Okay.
you know, when you boil it down, it's a decision for not really the city council to make. It's a decision for the voters to make when they approve or amend a charter to put into place an
Okay.
initiative and referendum process or a recall process, and then in many ways set up a structure for how they want that process to look in their individual city. So, you know, when you look at the legal framework, you have a very general statute that applies to all cities in Chapter 277 of the Election Code, and you also have, for cities that have adopted initiative and referendum in their charters, you have additional procedures within the charter that would have to be followed, and Paige talked about some of those. The League is still in the process of putting our legislative program together for next session, but what I think many home rule cities would say about this issue as it's laid out in the interim charge is kind of why would the city, or why would the state need to put uniform standards on petition requirements, whether it's the time frame or the number of signatures, when the way the system is set up right now, every community and the voters within that community control the process through the city charter? Because
Actually, that's what Paige had pointed out, that the things that caused a couple of these petitions to go down were state directed. So,
Right.
I mean, the state is overseeing the city's general or home rule. I mean, that's where it comes from.
no doubt about it. Yeah, the state certainly has the authority. Cities are creatures of the state. The state has the ability to say that. But what the
Madam Chair?
Oh,
Could I-
excuse me. Yeah.
Correct me if I'm wrong, but it would seem to me that once you decide that you're going to have a certain system, you're going to have charters, at that point, it would seem due process attaches, and a person in one city shouldn't have less right than a person in another city with respect to the process. So I would think, there are certain programs that you can adopt or not adopt,
Right.
but once you adopt them, I think folks have a right to due process, and I don't think at that point you really are on strong footing by saying, well, the state can't get involved and make us do it right. If you're going to do it, you have to do it right.
Yeah, and don't get me wrong, Representative Schofield, the state has every ability to get involved. That's without a doubt. What I would say about the due process component of it is if, let's say, a city has in process, in its I&R process, it says if you want to overturn an ordinance, you have 30 days. One city has that, another city has 60 days, another city has 90 days. If the citizens in that community felt that 30 days was too short, I would say that they do have due process under the statute because they can petition another petition, but it's under the state law guidelines to petition to amend the charter to put that in the charter, to extend it to whatever the voters wanted that to go to. So in some ways, we have a process set up where you can amend these. Well, we do have a process set up where you can amend INR requirements through the charter, also through this form of direct democracy that is almost circular in a way that we have the ability to amend that through the charter. But so yes, I understand your point, and I absolutely think the state can come in and if the state saw fit to place uniform requirements, it absolutely could. But I think from the city's perspective, the Home Rule Amendment, when it passed in 1912, set up, in a way, this license for the city government and citizens to communicate by being able to come in and put together a framework in the city charter to be able to say, here's how we as citizens want this city to operate. And the nice thing is that document isn't just static and in place from the time it was adopted back in the 1920s. There's a procedure in state law to allow citizens to come in and amend that document to change initiative and referendum procedures if they saw fit to do that.
Question,
Israel.
Mr. Lawley, it seems to me like you can't legislate good communication, and my instinct. I've never been a part of this process before, but we sure have done a lot of it in Austin.
Yeah.
But as you look ahead to your legislative agenda, is there something that your member cities are saying would be a legislative assist, or are we going back to what I was saying earlier, which is just everybody just act right, think through your project, talk to the people that you need to talk to, and get your details lined up?
You'd hope that everybody acts right, but if there is a legislative assist, I think
that phrase applies to so much in the Texas legislature.
It does.
But for your cities in particular, is there something that we could be looking to for January?
I hope so, and we again, the program that we have isn't finalized by any means, but what I would say is the things that you mentioned regarding communication, or that Representative Fallon mentioned regarding a website and getting all this information out there, transparency on how the process works, is something that we would absolutely be very willing to work on to make sure cities are getting that out there and being open and transparent about the process. And that, I think that would be preferable to going in and putting uniform standards, which, as has been mentioned here today, this is a very kind of the ultimate local control, is voters being able to have this direct democracy impact upon their city. It's grassroots. And so to be able to facilitate communication between cities and petitioners would be, I think, would be a very beneficial addition to the law.
Madam Chair?
Rep. Schofield.
You mentioned the ultimate local control is the voters having the opportunity to vote, but that threshold issue is what we're here talking about today. We're talking about instances in which voters couldn't get things on the ballot and couldn't get to vote, and whether we need to have uniform standards to make sure that they can in cities that have chosen to have it. So I don't think just saying local control really covers the waterfront on that issue. I think the voter doesn't get his local control if local control is the voter getting to vote when the voter doesn't get to have his petition heard.
Certainly through the initiative and referendum process, if they don't meet the petition requirements, then you're right. They don't get to repeal an ordinance, or if it's initiative, they don't get to adopt an ordinance. But when I say local control, I'm referring more to the charter amendment process to say if a citizen were displeased with the initiative and referendum procedure in state law, or in the city charter, then they could amend the charter.
But they don't get to amend the charter unless the city council votes to put a charter amendment on, at least in Houston.
No, the state law provides that you can petition for
You can
an
already
election.
get petition. Okay. So, but you're still, again, it's still circular. You're still going to the same city manager or whatever the official is with the same petition that they still might not let on to change the charter to change the vote as it did for whatever issue you were trying to get on. So I think, now I hear what you're saying, but I also hope that you're hearing what a couple of us are saying, in that if we're going to have petition and referendum at the local level, which I think we all think is a good idea, that it needs to be fair, and the voters do need to get to participate and not feel like they've been locked out either through a technicality of state law or a technicality of the city charter.
Sure.
Rep. Reynolds?
Thanks. And I guess this question would go to either one of you, but maybe specifically to you, Paige. If the voter had a question about the form, or you noticed that there was some kind of technical defect, are you allowed to, tell them that, hey, you need to do this to cure it without giving them legal advice, or are you not allowed to tell them specifically what's wrong with the petition so that they can go ahead and correct any technicality?
I think there's a fine line between providing legal advice and pointing out the deficiencies that are legal requirements. We many times communicate that through the non-lawyer staff, such as the manager's or office or the city secretary. I don't mind answering questions that help people assist with that process, and I have answered questions of even people that are here in this room. What I always tell them is it's not legal advice. If you have any reason that you feel like you need to consult with your own attorney, you should do that.
But the citizens, they wouldn't really have frequent contact with you. They're dealing with the clerks, right, when they turn in petitions in?
When they turn them in, but they have, the Plano staff is very accessible. I talk to people at city council meetings. I give people my direct phone number. I have other staff that can respond and are responsive, and the city secretary does the same thing, as well as pretty much city staff in Plano as a whole. Customer service is a pillar of what we provide in Plano, and we are very proactive in providing resources for our citizens.
So basically, they had ample notice of what the technical defect was and an opportunity to cure it.
With the Plano Equal Rights Ordinance, we did send the email with those outlining those issues. We were never contacted with questions that I'm aware of. And with the Plano Tomorrow plan, we let the petition circulators know before they circulated that the legal position of the city was that that is an issue that cannot be placed on a ballot.
Got it. Thank you.
I just wanted to point out, Bill, you were talking about, making the changes at the local level without legislative action. There was a bill that was filed last session with some of the, changes to make it more transparent, bringing in the new technology, website use, which they didn't have in 1912. A lot of it is we're trying to catch up with what's going on at lightning speed in technology, and to use it, for the average citizen.
Sure.
Has the city, maybe I guess this is to Paige, incorporated any of the things that were in the legislation from last session? It didn't get through. It died on the floor because, how things do. It didn't get a chance to get up for the vote. But, simple things like extending the petition period, to 90 days, from 30 to 90 days, putting up the website. Have y'all made improvements to the website? I mean, y'all could do this on your own, and it would save us a lot of time. And
We cannot extend the deadlines to collect signatures because they're in the charter. It requires a vote
It's
of the
in your
citizen.
charter.
It's in our city
Okay.
charter. So
So
that
we
would
do need-
require a vote of the citizens. But
Okay.
we could put information on our website.
make the website more transparent.
Make
So
it
some things
more
will need some
accessible,
legislative
yes.
action. Yeah, I see what you're saying. Okay. Any other questions, members? Well, I appreciate y'all being here very much.
Thank you.
Thank you. Look forward to seeing your suggestions for next session. Okay. Chair would like to call up Jim Delavue, board member of Plano Future, and Colleen Epstein, a Plano resident. Have they not filled out their form? Okay, Colleen, we need you to fill out your form, if you could, please.
Okay, where do I do that?
Right over here. She can help you. Yeah. Okay, give us a moment. Uh-huh. We have to follow all our technicalities here. And again, a lot of this is just fact-finding, informational, which I hope will help us next session. Is there anybody else on that list that hasn't? Yeah, let's do that right now. Okay. Dave Welch. There you are. Okay. We need you to fill out the form. So we'll, if you want to come up, and you can do it as soon as Colleen's done. You can do it. Oh, yeah. Go ahead. And we'll go ahead and begin if you want to introduce yourselves and begin.
Sure. I'm Jim Delavue, and I'm a citizen of Plano and represent Plano Future.
I'm Colleen Epstein. It's okay if I go first?
Yes. And I think Colleen was going to go first since she's speaking regarding the ERO, and that was first in the
Timeline.
issue that came up.
Thank you, panel, for hearing my testimony this morning on this important initiative to give citizens a voice in their government by reforming the petition process. I'm Colleen Epstein, representing a group of concerned and active citizens who in 2015 worked tirelessly to collect signatures for 2 different petitions that the City of Plano rejected. My colleague, Jim Delavue, will speak to you about the injustices that took place with our petition to put the Plano Tomorrow Plan to a vote, and I will talk to you about the problems with the Plano City Charter election system that resulted in our failed Equal Rights Amendment petition. The problems with the petition process are numerous and all favor the city. As I outline these problems, please note the underlined portions, which you will get when you get your printed form, which is in my car right now. Please note the underlined portions which represent action items that I'm suggesting for incorporation in any future legislation. The time frame allowed for petition drives can be challenging to meet, while the city can take all the time they like in preparing actions that citizens might oppose. For a referendum over an ordinance passed by the City Council, there is only a 30-day window to react. A petitioner has to craft a petition, notify like-minded citizens of the offending ordinance, gather a core group of petition signers, and mobilize an army to collect and notarize signatures. In most cases, there is not already an organized grassroots coalition to spring into action over issues that the city surprises us with. The city is able to fly under the radar, examining ramifications and preparing ordinances at their leisure, only to announce the agenda items 3 to 4 days before council meetings. To even the playing field, a 60-day deadline for turning in petitions would be much more reasonable. The city both makes and interprets the rules. As both judge and jury, they have virtually complete control of what can be an arcane and convoluted process. Very little is stated in the Plano City Charter about the petition process and is confined to sections 6.02, 6.03, 6.04, 7.02, and 7.03. And there is no mention of the fact that further state regulations also apply. Because the Texas Election Code is over 900 pages, and I know because I tried to find the link that Paige referred me to, the links to the applicable pages should be included in sections 6 to 7 of the Plano City Charter document. Because of this ambiguity, the city holds all the power and almost anything can be ruled out of bounds. Citizens seeking to craft a petition are left to guess at all possible ways that it could be found in violation. After the city rejected the 8,000 signatures that we had gathered on the ERO petition, I tried to find a foolproof petition template to avoid the same travesty from happening to the Plano Tomorrow Plan petition. I requested that from the city secretary that she provide copies of all the petitions that had been filed in the last 15 years which had been successful in resulting in an election. Predictably, the city waited until the last day required by law to respond to my request. I have here in my car a copy of the letter that states that the cost to supply such information would be well over $400. By the time I received the city's response, Plano Future had already hired, and Plano Future is the group that Jim represents, had already hired an expensive attorney to get the process started on the Plano Tomorrow petition. They simply could not wait because of the tight 30-day deadline for submitting the petition to the city. If the city were required to provide online petition templates and more thorough and specific instructions, it would facilitate transparency and, I'm sorry, there we go.
All right.
Sorry,
It frees
my-
up on me all the time.
Okay. If the city were required to provide online petition templates and more thorough specific instructions, it would facilitate transparency and save the taxpayers so much money and frustration. Included in that template would be a column for county and either a voter registration number or a date of birth. These were both items that were missing on the ERO petition because the city charter document makes no mention of them. Another example of ambiguity in the Plano City Charter is Section 702, which states, each copy of the petition shall have attached to it a copy of the proposed legislation. The citizens who had to quickly put together the ERO petition read that as, attached to your petition should be a copy of the name of the proposed legislation. Indeed, which I admit was a misunderstanding. Indeed, at the top of each petition page, they did list the name of the proposed legislation that they were seeking to repeal. Although the city did send out a clarification email, all recipients were unaware of that email until after the petitions were rejected. Then they checked their mailbox and found that the messages had been sent to a blind copy group, which flagged the messages and sent every one of them directly to their junk mailbox. I spent 12 hours researching for this hearing, and it wasn't until 4 o'clock this morning that I finally found a link to the city charter. I searched all the logical pathways. I typed in petition, city election code, and actually went through 166 entries under petition, but there were no links under that search heading. There should be an obvious path to the petition rules, which, as I did say, I did finally find on the website, but it was very difficult and not logical. Learning from the mistake that we made with the ERO, when it came time to craft the petition to repeal the Plano Tomorrow Plan, I called the city secretary's office. Since the Municode site just says attached, but it does not outline how the petition is to be attached, staples, bound book, etc., I asked her if we must attach the complete ordinance to each single page of signatures. I asked her if we could take a copy of the ordinance of the Plano Tomorrow Plan to Kinko's and have it bound in a book with lots of blank petition signature sheets at the back of the book. She said no, it has to be attached to each signature sheet. I also asked her how could they tell if the entire document had been attached to each sheet before or after we had someone sign it. She said that is part of what they look at and how the staple is attached. I suspect they also look for similar creases and wear and tear on both parts of the documents. more ambiguous unspoken rules. The Plano Future Committee decided to make petition booklets of many signature pages attached to the 50-plus pages of the entire Plano Tomorrow Plan anyway, I suppose because of the expense of a 50-page document attached to a single page would have been outrageous. But we never did find out if that would have been accepted as the city threw out the petitions without even counting the signatures. I could go on, but if you want, I could stop for questions or I could keep going. Let me know.
Any questions, members?
I've prepared more if you want to hear more.
Oh, Reverend Reynolds.
So is it your testimony that you never knew what the deficiency was?
I was not one of the preparers of the ERO. I was one of the circulators, and it is my testimony that the petitioner, the originators of the petition, all said that they were not aware of the regulations until after the petition was rejected and the city made their statement saying that they had sent an email to each one of the people originally organizing it. So they went back and searched their email and found it in the junk box. So no, they were not aware of any of these violations. They weren't aware that you had to have county on there. They weren't aware that you had to have either a birth date or a voter registration, and they're not on the website. If you go to the website, it doesn't mention anything about extra ordinance or extra regulations that the state has. It doesn't have a link to it or anything. There's no way to know it, and a template would be wonderful. And as I say later on in my testimony, when we tried to get information from them, they were very evasive.
And just for clarification, you said that they did receive an email, but they didn't get it because it went to their junk mail.
Yes, each one of the originators of the petition, and there were about 5 different people who were involved in that, it was sitting for them in their junk mail, but they were unaware of it. So the city keeps bringing this up.
Because it was BCC.
So they actually did do what they say. They did try to let us know, but they sent a blind copy, and so I guess I'm not sure too much how junk mail works, but because it was blind copy, it was never received.
All right, thank you.
Okay. Any other questions? Okay, thank you.
Okay. Good morning. I'm Jim Delavue, and I represent a citizens group called Plano Future. Thank you for allowing me the time to talk to you. In 2014, the City of Plano proposed a new comprehensive plan. Under Texas law, comprehensive plans limit and guide a municipality's adoption of zoning regulations and provide the framework for the decisions of city staff, planning and zoning, and the city council regarding land use. When the citizens reviewed the proposed plan, we determined that it included several elements that were a departure from Plano's historical comprehensive plan and that we did not agree with several of the proposed changes. Our concern was focused on the intent to add a great amount of high-density housing in over 20 areas of the city. High-density residential development was not allowed in most of these areas under the existing comprehensive plan or current zoning. Hundreds of citizens attended planning and zoning, city council, and other public meetings on multiple occasions to voice their concerns, and citizens sent the city over 1,000 letters and emails with specific objections to the plan. The city adopted the comprehensive plan by ordinance anyhow without making any of the substantive changes requested by the citizens. Except for tax levy ordinances, Plano's Home Rule City Charter allows citizens' petitions to require that any newly adopted ordinance be suspended and put to a vote of the citizens before it can become effective. The petition must be submitted within 30 days of enactment of the ordinance and include a sufficient number of signatures of registered voters. Immediately before the City Council vote on the new comprehensive plan, the city attorney announced that filing a petition to require a citizen's vote on this matter was not allowed under state law. This statement was intended to intimidate and discourage any citizen's attempts to challenge the comprehensive plan. The city attorney made these statements stating that in spite of the city charter, it was an incontrovertible fact that such an election could not be allowed under state law. When pressed for specific laws as to why there could not be a petition for a citizen's vote on the ordinance, the city attorney pointed to a state law that says zoning actions cannot be subjected to a vote of the citizens. The citizens pointed out that the comprehensive plan states several times that the plan, quote, shall not constitute zoning regulations. And such statement is in fact required by Section 213.005 of the Texas Local Government Code. When citizens challenged the city attorney's position, the city attorney responded that since the comprehensive plan was part of the basis for zoning actions, it too cannot be subjected to a citizen's vote. When asked to cite case law that was directly on point, the city attorney did not do so, but instead stated that this was her interpretation of the law. The citizens group, on the advice of council, believed that there was no basis for the city attorney's position. It took over a week for the citizens group to reach this conclusion and decide to launch a petition. Only 21 days remained to complete the petition under the city charter. The citizens gathered over 4,000 valid signatures in the abbreviated time, which was more than the approximately 1,800 signatures the city contends is required. The citizens submitted the petitions to the city secretary. Every effort was made to follow the legal requirements, and the petitions were vetted by the citizens' attorneys. In spite of the requirement of the city charter, the city secretary refused to count the citizens' petitions at the instruction of the city attorney, claiming it was impossible to have citizens vote on the comprehensive plan. Under the city's charter, the new comprehensive plan should be suspended automatically upon submission of the petition. The city has nonetheless been operating as if the new comprehensive plan is in effect. The city has compounded the legal issues by enacting zoning amendments that are invalid because they're based on the suspended comprehensive plan. The citizens demanded on multiple occasions that the city secretary fulfill her duty to count the petitions and present them to city council and suspend the ordinance, but they were rebuffed. When the city did not act, the citizens filed a lawsuit. Attorneys advising the citizens group feel that, at best, the city was taking a novel interpretation of the law, and it appears likely the citizens will prevail in court. The city has sought to extend and delay all court actions. Shockingly, the city filed a motion with the district court claiming that it is immune to suit and that judicial review does not apply to it. The citizens group and their attorney replied, the district court denied the city's plea. The city then appealed the district court's ruling. The citizens group and their attorney replied to the city's appeal, and again the city waited several weeks before submitting a response to the appeals court. In that response, the city also asked for a hearing before the appeals court, even though the question of jurisdiction is relatively mundane and all arguments were laid out in writing. All of these actions by the city are intended to drag out the litigation process, adding to the time and cost incurred, and hopefully frustrate its citizens and cause them to give up the fight. After the citizens made every attempt to work within the system and follow the law, to no avail. After 11 months, the citizens are still waiting for a ruling on the matter, and there is no doubt the city will continue to appeal and delay through court actions. There are a number of actions that could be taken to give citizens' petitions a better opportunity to prevail. In the interest of time, I am going to discuss a few quick points, but there are many more. Number one, allow more time for petitions to be completed. Although Plano Future was able to complete the petition process on time, doing so was very difficult and required a Herculean effort, and only happened because the citizens were already very well organized through months of effort to get the plan changed. As citizen groups are not well organized and funded, some latitude should be required to accept petitions that have only minor deviations. After all, the worst outcome is that the city would have to allow the citizens to vote on the matter. Clarify that a city does not have immunity from litigation, and clarify the proper venue for filing actions. Require the city secretary to immediately count all petitions presented and release the findings as to the validity of the signatures. Require the ordinance be suspended immediately when a notice of intent to file a petition is filed with the city secretary. If the citizens submit a petition with an adequate number of signatures to require a vote, the ordinance at question should continue to be suspended until the city prevails on any contest of validity in a court of law. This would put the onus on the city to resolve the matter instead of seeking to fight a battle of delay and attrition. Also, you might consider an administrative procedure for a state agency to evaluate the petition so the city cannot be litigant, judge, and jury. I want to speak to a couple of points that have been made here. One was, first of all, we did submit the form to the city secretary in advance of obtaining any signatures to ask if it was adequate, fully cognizant of what had gone on with prior petitions. The city secretary informed us that we could not have a petition on the matter and gave us no feedback on the form. With respect to the statement that there were misrepresentations, there were absolutely no misrepresentations in the form that was circulated by Plano Tomorrow. The only statement beyond saying that it referenced the ordinance and including a copy of the 50 pages of the ordinance was that it was requested that the citizens vote on the ordinance. And there was no other statement, could possibly be no misrepresentation.
Madam Chair, I have questions of an expert on the INR process, and I would think that's our municipal league person. Is that right? Okay. If it's appropriate, when it's time, I have a couple of procedural questions. Yes.
So, you have your testimony in writing?
Yes, you have a copy of it.
Okay, we got it. Good. All right, well, I appreciate it very much. I'll be very
Okay.
much. Thank you.
Thank you.
Yeah, I have a couple of questions that I think the municipal league can help me with.
You got him here?
I can certainly try. Bill Longley with the Texas Municipal League.
Well, Mr. Longley, you're our expert today on this process, so it's all on you.
All right, no pressure.
When someone is going, I want to be respectful of folks who care enough about engaging. Lord knows that's what this committee should be about. If people care enough and have the heart and the desire to get involved, and I want to give them the tools to do that. But if someone's going to begin this process, my understanding is that they need to know some facts and data about how many voters there are, because it's a percentage of those voters that will then dictate how many petitioners they need to have.
Right.
Do you think that there's a legislative fix to help with the information sharing aspect of that? Because a lot of that can be quite overwhelming to someone who's not familiar with how to go about researching that and getting that clear with the city before they start gathering signatures.
Mm-hmm. Potentially, yes. I think, going to your comments earlier, and Representative Fallon, your comments earlier about, websites being ways, where you could put information on, number of signatures, time frame for submitting those signatures, whatever else you want to about the procedure that's in place for in city charters, in addition to what's in state law. Sure, I think that's something that I think is worthwhile to look at, and we'd certainly be happy to work with y'all on that.
And anecdotally, I know you may not have the exact numbers, but do you know from your member cities' experience, I would not want groups who have a desire to get involved and make a change to have to hire an expert or an attorney. And do you know to what extent that's a common practice?
I don't. I don't know if I could quantify that in any way. We've seen, there have been challenges, not just in Plano. We've seen challenges in City of Houston comes to mind. City of Austin, there was a fairly high-profile initiative election this past year. So oftentimes the issue is political enough in nature, and you have strong enough interests on either side where I think attorneys are hired because you often have sort of strong interests that want to see to it that they get a favorable outcome. But no, I think there are of course other situations where you wouldn't have.
What I'm hoping that we can be helpful in terms of giving voters all the information that they need from their city, so that they don't have to hire an attorney, and that they know exactly what the rules are. Mm-hmm. This is how many signatures you need. This is the format that you need. So I would be interested in helping with that process. But we look forward to further discussions before we gavel in to see if there's a reasonable remedy. But thank you for your time.
I think,
Thank you.
Kind of reiterating what Rep. Israel was saying, I don't think, having listened to the previous testimony from the citizens, that they're complaining about the requirements. They're just saying, let us know in an understandable way what they are.
Sure.
Be reasonable about it.
And I would think that I think many cities do that. There's no way unless you wanted to go into every website and look to see what is on each home rule city's website that has initiative and referendum. It'd be a tough undertaking. I think a lot of cities do that, but again, if there's some sort of legislative fix to
maybe that's what we could
to assist communication between cities and citizens, we would welcome the opportunity to work on it. Again, I would. That's something that I think makes sense. Speaking before we know what we'll see next session, I think our member cities might be a little more reluctant to see legislation that goes in and says, your voters put in 30 days, but we're going to say now that your voters' opinion, your citizens who put in 30 days in the charter, that opinion
in 1912?
Well, or sometime more recently than that, or that they have the ability to amend the charter and put in a longer time period. It's almost as if those.
Well, that's what we're talking about. It kind of gets into this, dog chasing his tail kind of thing. And I think what they're just saying is make it very clear. So, as Rep. Israel pointed out, they shouldn't have to hire attorneys to help them do a citizen, grassroots.
That I think we can work with y'all on.
That's what we're looking for. Thank you.
Thank you.
Any other questions, members? Okay. All right. Panel number 3 is Mr. Andy Taylor. And you are your own because you are unique in this whole issue. And you've seen it from both sides.
I have.
Go ahead.
Madam Chair and Mr. Vice Chairman and members of the committee, thank you for the invitation to come and speak. For the record, my name is Andy Taylor, and I am primarily an election lawyer. I've been practicing election law for about 30 years, and part of my practice involves being in these kind of fights you're hearing about. You heard about Plano. You'll hear a little bit from me about Houston. It's really where the city government comes up against the average ordinary citizen in the context of the citizens wanting to petition the government about something. If it's an initiative, the citizens are saying, hey, we think there's a law that you ought to pass, and you haven't passed it, so we're going to take your seat and try to pass it ourselves. And so they do that through a petition process. There's a referendum right in many city charters, and that is where the citizens are saying, hey, you've passed an ordinance that we don't think makes any sense, and we want to get rid of it. And so we're going to, through the petition process, try to take your seat, and through an election, try to get rid of it, and that's called a referendum. And I've practiced in that area my whole career. What I'd like to suggest to you is that there are some very easy, common sense changes that the Texas legislature could implement to make it easier for citizens to exercise their right to petition government for their perceived grievances at the ballot box. And I want to begin by talking about deterrence. You heard some back and forth. You're not going to be able to decide who's right and who's wrong about was this petition valid or was it invalid. But you saw how strongly both sides feel about it. And so ultimately, when you have a train wreck between the citizen and the government on whether there's a right to vote, it's going to go to the courthouse. But there are two things that are lacking that I think fail to accord the citizens the power that they deserve to level the playing field between the strong government and the ordinary average citizen. And I'm going to give you two examples. In Houston, not once but twice last year, I had to file something against the city and the former mayor called a mandamus petition. A mandamus petition. That is the legal procedural vehicle by which you try to get a court to step in and tell the government and the citizens who's right. Is this petition valid or not? And so it's called a mandamus petition. Well, guess what? Under the Constitution and under state law, the winner doesn't get their lawyer fees. So even though I filed a lawsuit on behalf of 54,108 law-abiding citizens who signed a piece of paper, who behind them were over 400 churches standing side by side with Republicans, Democrats, independents. The thing that bound all those people together was the desire to have the right to vote. And so it wasn't a Democratic or a Republican issue. It was a right that we all should enjoy. And yet it cost us $650,000 in lawyer fees to go all the way to the Supreme Court twice. And we won with unanimous decisions. So it wasn't a lack of clarity here. I mean, the Supreme Court of Texas said, you're not only right, but you're unanimously right. And yet, because it was a mandamus petition, we could not recover our fees. And so, suggestion number one, change the law to say that if citizens file a mandamus petition to force a government actor to comply with their constitutional or statutory duties and win, that they should prevail, including the reimbursement of their fees. Why? Well, then that is a check and balance against the government. The government has a lot of resources. They have tax dollars that go to their budgets. They have legal offices. They have, incredibly competent city attorneys and staff. But the ordinary citizen doesn't know much about that, and this may be their first and only foray into the democratic process at the local grassroots level. And so the city needs to know, hey, if you're going to deny the petition, there's some risk in denying the petition, because if you're wrong, you're going to have to reimburse these citizens for their costs in terms of legal fees. So that's suggestion number one. It's only fair. Suggestion number two is a third case. I had 3 cases in the Supreme Court last year, all against the city of Houston, all of them unanimous victories. I already just told you about 2 of them, but the third one had to do with what's called an election contest. What happens in the citizen petition process is that if you're lucky enough to get the government to say, yeah, this is going to go on the ballot, they agree with you. Or if you're unlucky and they say no and you have to sue them like I did and go all the way to the Supreme Court, but you finally get the victory that says, city, you got to put it on the ballot. Either way, once it's going on the ballot, The city is the one, under the law, that gets to write the ballot language. They get to craft it, even though the citizens are the one who put together the petition and wrote the ballot language and said what they said in the document and got a bunch of people to sign it. They don't get to control what goes on the ballot. And we all know that when you make an election decision in 30 seconds and you're there at the ballot box and you may not know anything about the issue, you're going to make a judgment very quickly based on that language. So the city has enormous power to either subliminally or explicitly cause you to maybe think something's good or maybe think something's bad just by the language that they choose. Well, guess what? So in a case that I call the rain tax, where $800 million was charged by the city of Houston against its residents, I filed a lawsuit, went all the way to Supreme Court. Supreme Court unanimous decision said that ballot language was false and misleading and deceptive, causing a voter to want to vote for it rather than against it. They eradicated the entire ballot, voided the outcome. Guess what? In an election contest, you don't get lawyer fees. And then let's add some insult to injury. You don't even get your court costs reimbursed. There is a section in the election code, I kid you not, it's section 233.003C, like cat. It specifically says 233.003C, like cat. That's the Texas election code. What it says is when the ordinary citizen files an election contest and wins, the citizen has to pay the court costs of the government that lost. And so in my case, where we eradicated $800 million of taxes that were wrongfully assessed on the Houston citizenry, we had to pay over $10,000 to the city. That's crazy. But that's what that statute says. So suggestion number 2 is, in order to have a disincentive and to level the playing field, if you're in court, let the winner, the citizen, get their fees and let them get their court costs. Now I want to jump into...
Excuse me.
Sorry, Mr. Taylor, I don't mean to interrupt you,
Vice Chair.
but since we're on that subject, do you have any idea how that got in the statute, the history of it, or who put it in, or what year?
It was,
why?
I think it was 1985, if I'm not mistaken.
I have no idea the history of how or why.
I'm not versed in why it went down that way.
You think it was 85?
I think so.
Okay, we'll research it and
Quiet
find out.
little amendment.
Yeah, we'll
Right.
We'll research it and find out.
So, but I think it should be changed. Okay, now I'm going to give a couple of quick, common sense, suggested changes for the actual process. First of all, state law already accords 6 months, 180 days, for a citizen petition signature to be valid. I think that's good. That's fair. 180 days. You can find that in section 277.004 of the Texas Election Code. So that's good. But here's the problem.
Madam Chair,
Yes.
can you elaborate on that? I don't think I understand what you mean. Say
So
that again.
the citizens that, in fact, the gentleman and the lady that were just talking to you, they asked for 60 days. What they said to you is that we as citizens, we need more time to gather signatures.
Okay.
We need more time.
But-
what I'm saying is that state law gives them 180 days, but there's a loophole, and I'm going to tell you about the loophole.
They only had 30 days.
Exactly. I'm going to give you the loophole.
Okay.
So what I'm starting with is I'm telling you 180 days, in my judgment, is fair. Why is it fair? Well, let's talk about Houston quickly. You have to gather at least 17,000 signatures, at least. And that number typically escalates over time. I won't go into why. Well, in my experience, there's usually a 3-to-1 problem. If you have 3 times the number of signatures that you need, you're going to lose 2/3 of them. So every 3 signatures, you're probably going to lose 2. So you're only going to get 1. So what I always advise my clients is, okay, if it's 17,000, take it up to 51,000. You need to get triple what's required, because there's going to be just human error that causes these things to be disqualified. So think about it. We're trying to gather 51,000 signatures in 30 days. That's difficult. So state law, 180 days is fair. Now let me tell you why there's a problem. There's a loophole. It's in 277.004. And I jumped over. I should have told you earlier that the 180 number is from 277.002, subdivision C. So 180 is in there. But 277.004 says unless the city in its charter says otherwise, and then they put a date in there, September 1, 1985. So let me tell you what that means. So you mentioned 1912, Madam Chair, earlier. In 1913, the city of Houston in its charter said, we're going to have 30 days to gather signatures when you want to repeal a law through a referendum process. Well, back in 1913, you know, the numerosity requirement wasn't very high. You had to get a couple of hundred signatures. And so, you know, you get on your horse and buggy and go down the road in the farm area and you get a couple of hundred signatures in 30 days. That's doable. But taking 1913 to 2016, now all of a sudden, in 30 days, you've got to collect 17,000 plus signatures, or if it's a charter amendment, 20,000 signatures in Houston, Texas. So my point is this.
Okay, so you're saying basically the home rule charter
It's trumping the state law.
Okay.
Madam Chair, can I ask you a quick question?
Schofield.
You just pointed out to us that state law gives a blanket requirement of 180 days unless the state charter says otherwise. Are you aware of any city charter says otherwise? Are you aware of any cities that put in their charter more time than 180 days?
Of course not.
So every one of them that made a different number restricted the time the citizens could get signatures.
Correct. And it's usually 30 days. Sometimes it's 60 days. But now here's the other flip side problem. So what I've told you so far is 180 days is fair, but there's a loophole because the code says unless the city says otherwise. And they always do, and it's always less. But then they put in this date, September 1 of 85. So here's the problem. Let's say that a city, and Representative Fallon, you were asking this earlier of one of the witnesses, why not just voluntarily make it easier? I mean, why do we have to wait for the legislature to do it? Do it yourself. Well, guess what? If the city wanted to give more time, they don't have that power. They couldn't give 181 days or 210 days because what the same statute says is they can't do anything after September 1, 85. That's the cutoff. So the city can't fix this. The city can't make it easier. Only the legislature can make it easier.
Okay, so if we already have 180 days in legislation, but it's trumped by city charter. So if we pass more legislation, is that going to be null and void as well?
What I would recommend is that you repeal the portion of 277.004 that allows a city to trump the numerosity or the number of days.
So we have to repeal
Just say it's 180 days, period.
Period. Gotcha.
Period.
But we have to take out.
You got to take out that
section.
loophole.
Yeah, okay.
That would fix it.
Gotcha.
Next suggestion, standardized forms. I think standardized forms would largely solve everything you've already heard this morning in terms of problems with these petitions being denied. Either have the Texas Secretary of State given the responsibility to oversee what kind of a form is required in all of these different venues, or tell the cities you have this power, you meaning the legislature, have this power to tell the city you've got to promulgate a compliant form. You're responsible, not the citizen, you're responsible for telling the people who want to exercise the right to vote what form gets the job done. Make the city do that and make them put it on their website. And if they don't want to use the promulgated, pre-approved form that the Secretary of State recommends and they want to use their own form and keep that power, that's fine. But if there's a mistake and that form doesn't comply, too bad. That goes against the city. Let me give you a common sense example. So I'm fighting in Houston last year on a case, and the city's form had a fatal defect in it. You get on the city's website, and it was missing a signature line.
But they required a signature line.
They required it. So
And
here's
the
what
form
happened.
did not show it.
Exactly. Pastor Dave Welch, who's here in the audience, great man trying to exercise his rights. He's not a lawyer.
Yeah.
He pulls this off the website, and he doesn't have a signature line on the document. And so 54,108 people sign this document, but it gets all fouled up because this line is missing. And so a year's worth of litigation later, we were able to get around that problem, but it was costly, $650,000 to try to fix it. This wouldn't have ever happened if either the state of Texas told the city what form would be compliant, or if the city had put a compliant form on their website, or if the form that they used was defective, they couldn't then use it against the citizen and say, ha, you trusted us, your form's messed up. But conversely, say, that's your problem. That's your problem, city, because you messed up the form. So my suggestion here is standardized forms.
Madam Chair,
Yes, go ahead.
I think this goes back to what I talked about with the first witness, which is if you're going to, as a local home rule city, decide to have this process, you have to provide due process to the people who are using it. If we allow local counties to have drug courts or veterans courts, just because it's being run at the local level doesn't mean that they don't have to exercise due process in their court. And I think the same thing applies here. I think if we're going to have initiative and referendum, whether you live in a city in my part of the state or in Representative Fallon's part of the state or somewhere else, you ought to have due process. And I think a standardized form that they can no longer say, oh, your form isn't valid because it's been promulgated either by the state or by the city makes a lot of sense.
The next suggestion is let's put a deadline on the government. How come the deadlines are only on the citizens? So if you want to play the game of you only got 30 days to get the job done, okay, well then city, you've only got 30 days to tell us if the petition's valid or not. Now there are some cities that have that, but not all of them. So it seems to me that
Consistent.
you need a consistent, uniform rule about how quickly does a city need to act. Some cities, I'm sorry to say, sit on these things and don't act promptly. And there's really no way to force them to act quicker in a courtroom because they have discretion. And discretion and time is something that's so fact-intensive. And so I suggest that you consider telling not only the citizens how quickly they need to act, but the government how quickly they need to pass it or reject it. The other thing I think would really help is a right to cure. Let's say that the citizens, despite all their best efforts, foul up the form, and the government comes back and says, I'm really sorry, we respect your rights, but it's all messed up. Right now, there's no way to fix it. You don't get a second shot. You're out. So you got to go gather another 54,108 signatures and start over. That's ridiculous, in my humble opinion. I think we should give the citizens a chance to fix it. So let's give them a right to cure, maybe 30 days, whatever, so that they can fix what's wrong. The government knows, because they deal with this all the time, it's their wheelhouse, what's wrong with the form. So let's get them to tell us what's wrong, and then let's fix it. And that would solve a lot of problems.
Madam
So-
Chair?
Representative.
Mr. Taylor, I could see where you're clearly talking about if you have a technical defect, you don't have a line for county or whatever. Are you equally saying that if at the end of their evaluation of your signatures, they decide that you have 130 fewer than are needed, that you get to keep the valid signatures you have and have a certain amount of time to go get more, or are you just saying with technical?
Absolutely. And here's why. Let me give you an example of what I went through in Houston. A lot of people know their date of birth, but they're not sure about their voter registration number. And one of the columns doesn't tell you that you could do date of birth instead of, so they leave them blank, and then all those get rejected. Or Some people on the right side of the form are supposed to put the date of signature, but somebody writes down their birth date instead of the date of signature, and then the next person who signs this form only looks up one line and go, oh, we're supposed to put our date of birth here. And all of a sudden you got 500 people who are putting the wrong stuff on the form. That happened in our case. And so when it got turned in, all those got rejected with no chance to fix them. But those citizens just made a mistake. All they need to do is change it to date of signature, and we should have been able to resubmit them. Last thing, this maybe is more of a platitude than a law, but the right to vote shouldn't hinge or otherwise depend on good handwriting.
Amen.
In Houston, 8,100 ordinary average citizens were disenfranchised and had their petitions invalidated because the government said they couldn't read their signatures. That's not the America that I know, and that is not the Texas that should exist. And I would suggest somehow, some way, you work it into the law to say to the local government who has all the power, hey, play it straight. Everybody has a right to vote. It doesn't matter how good your handwriting is.
Threw out all the doctors, didn't you?
Madam Chair, I have a couple questions.
Yes, Representative.
Ms. Taylor, thank you for your presence here today. You made a lot of good points. And I had a couple of mechanical questions for you because I'm drawing on vague memory. I got on, I've used some of these forms because I got on the ballot by gathering signatures to waive a fee. Does each sheet need to be notarized?
Yes.
That was troublesome for us because sometimes we would go to a community event and it would be half a sheet and then go to another thing. So
right.
Remind me about the notary part.
Well, and what's interesting is the form that you're referring to is a perfect example of how to make it clear to people, because the form is a promulgated, pre-approved Secretary of State form. And it has fly-specced the Texas Election Code and gotten everything correctly put on the document. There's not any thing about that piece of paper that is wrong. And so we know that that document is accurate. So if somebody's trying to get on the Republican or Democratic primary ballot, they know exactly what to put on that piece of paper. That piece of paper does include a certification requirement that's under oath, and that is the role of somebody who's called a circulator. So what happens is, let's say you have one page where 20 people can sign. The circulator has the responsibility to go to those 20 people and get the signatures. The ordinary citizen's not signing under oath. They're just signing required information. But the gatherer, who is the circulator, has to swear under oath that they've done their job correctly. And so that's at the very bottom of each page.
So how can just knowing how crazy some of these things can be, a circulator might have started one sheet but didn't finish it? Did you have any signatures that were invalidated because of this in your Houston experience?
Thousands.
And if so, how many thousands? Do you remember?
I'm guessing, but I would say it was about 7,000 because the circulator didn't sign the document at the bottom. And so, you know, the idea behind the circulator requirement,
That was a lot of.
it has a pro and con.
That's a lot of votes that were individual voters whose concerns were discounted because of that.
Right. Now, the argument for a circulator affidavit is you want to make sure there's no fraud involved. So you don't want somebody who just makes up, Tom, Dick, and Harry and then turns it in. That's not the democratic process. We want to play by the rules. So it's okay to have a circulator affidavit requirement, but there are things about the circulator affidavit requirement, in my mind, are too draconian. So, for example, they're saying that you have to actually personally see with your eyes, you, representative, sign the piece of paper. So the circulator couldn't go into a room or a restaurant and put it down, or a church and put it down and just kind of sit there and hang out and wait for everybody to sign it. No, you have to personally swear under oath that you saw it with your own eyes. That's probably going too far, in my view. But we can debate the wisdom of the circulator requirements all day long. The bottom line is the law requires it, so we have to do it. So the form needs to be clear so nobody makes a mistake.
Is there, in your experience, is there a Texas city, or maybe not a Texas city, but preferably, is there a Texas city that you think is a good example of clarity and communication and working with citizens on these types of initiatives?
I'll have to make a disclosure before I answer this question. I represent the city of Plano on the Tomorrow Plan lawsuit. So I want you to know that before I say that I believe the city of Plano did it correctly there. I know Paige Mims, and I hold her out to be a person of high moral character and who tries to play it straight. I'm not objective. I'm their advocate, and I wanted you to know that. But here's the point I would make that's more broad, whether it's Plano or anywhere else. Whether the citizens have a power to initiate legislation is something that is defined by law. I call it the strike zone. So when the citizen metaphorically throws the pitch across the plate, it has to be in the strike zone in order for it to be valid and lead to an election. If it's a ball, if it's outside the strike zone, then sadly it's not worth the paper it's written on. So any city that receives a citizen petition needs to know, is this in the strike zone or not? And Plano believes, and I agree with them, that the Tomorrow Plan is part of zoning and that's outside the strike zone. I do redistricting litigation. I've been the chief lawyer for the state of Texas over 3 different decades for all these legislative and congressional redistricting battles. I will tell you that redistricting, by its very nature, has hearings, testimony. You've got to get on Red Apple. You've got to comply with the Voting Rights Act. You have to go through a minority analysis to make sure that you're not harming a district. It's got to be performing, et cetera, et cetera, et cetera. That doesn't work at a ballot box. You can't make a redistricting plan subject to a vote at a ballot box, because if people just vote the way they feel, all the districts are going to be unconstitutional and illegal. And so there are some things that just aren't susceptible to citizen petitions. Annexation, zoning, redistricting, those are the things that are outside the strike zone.
Any other questions? No.
Thank you.
Thank you, Mr. Taylor. Thank you very much. Our next panel, Peggy Venable representing herself, and Pastor Dave Welch, the president of Texas Pastor Council. Please come on up. Good morning. Welcome. Thank y'all both very much for being here. Ms. Venable, if you'd like to
You bet.
start,
Thank
go
you so
right
much.
ahead. Absolutely. Thank
Good
you.
morning. Thank you so much for inviting me to testify. I'm pleased to be here and appreciate the speaker putting this on as his interim charges. Let me start off by saying that I consider
And I'm sorry, Ms. Venable, will you just for the
Did I
record
give my
introduce
name?
yourself?
I'm
Yes,
so sorry.
that's right.
Peggy Venable.
We're all
I'm here
rusty,
representing
right?
myself. My apologies. I failed to do that starting off. I first want to say that I consider people who are petition gatherers and involved in that process as real heroes, whether I agree with what they're petitioning regarding or not. They are involved and engaged in the process, and they deserve every opportunity for a fair shot at accomplishing their goals and objectives. I have to say, having listened to some of the testimony, it's really no wonder that so many citizens are cynical about their government at every level, because some of them feel like and actually seem to experience that their government is working against them and not for them. I do have some recommendations, but based on what I've been hearing today, I wanted to point out something that I think could be helpful and is really far too simplistic perhaps, but let me start off by saying I do not agree with the petition gathering process of the tax rollback. I believe that a rollback should be automatic, no petition gathering process. Having said that, we in the state do have a petition gathering process in place. I will use that as an example because on the comptroller's website, and I could certainly email this to the staff and it be shared with everyone, but on the comptroller's website are very clear instructions for citizens on how to conduct a rollback election. They talk about the petition process and determining if it's valid, holding an election, and then act on the election. On the right-hand side of this very page, they have a sample rollback petition. So they actually provide potential petitioners with this form so no one could be confused. There's an actual form right there. And I think that's what many of us are thinking about and talking about as we listen to some of the petitioners and their concerns about the petition not having all of the accurate information, whether it be county for the signer or what needs to be on there. So I think that could serve as a bit of a template for what local governments could do in putting on their website just what petitioners, to answer all their questions and to give them a template or a format for just what their petition needed to look like. I'll go quickly through because I don't want to take up more time than is needed, but I agree with Jim from Plano Future on needing more time for the petition gathering. I will say here on the comptroller's website, again, our example, which I want to eliminate. Let me also just say that. I'd like to eliminate the petition gathering process on the rate rollback. However, this is a great example of what could be done, and they do, of course, allow 180 days. In this process. So again, I would look to the comptroller's website as the template perhaps for that suggested language, which is my second recommendation there, that there be a petition template or suggested language. I think too, knowing that this is one issue and the petitioners may have various issues, it could be that there's no one template that serves every purpose. So I would suggest that the petition gatherer have an opportunity to draft their petition and take it to the city, and a city official have a set period of time. I'd suggest they ought to have 24 hours or one business day to approve or reject and make recommendations on the petition. Should it be needed, recommendations be needed. So I think there should be a timeline, but the petitioners could actually ask the city, is this language valid and acceptable and illegal? And the city say yes or no. Again, I also have to say I agree with Andy Taylor that the right to fix it ought to be there, that whatever number of days it might be, that if the petition gatherers, as they do go to a lot of time and trouble and expense to gather these petitions, if there is a problem, there should be an opportunity for the petition gatherers, a set period of time where they could go back and try to fix that problem and bring it back to the city. And finally, I think some of these measures need teeth. And I will tell you, I've dealt with citizens across this state, whether it be in New Braunfels or Houston, heaven forbid, the poster child for this, or Plano or Austin. There are problems. And I think that there seem to be no teeth in this, that the citizens have no recourse other than to sue. And that's very expensive. As you know, Bruce Hotze in Houston is spending, hundreds of thousands of dollars, I think, still suing the city of Houston over the spending limit issue. And that was, back in 2004, I think. So I think we need to make sure that there are some teeth in it such that the local entities should be forced to comply, and that would make the process more fair. Again, I think citizens are increasingly cynical and skeptical of government, and some of these practices maybe give these citizens reason to be. And good government is certainly dependent on transparency and on working with the citizens in good faith. And I think that it's unfair that cities have resources to fight these local petitions, but where do they get their resources? They get those resources from the very citizens that may be petitioning the government, and they shouldn't be having to pay twice to fix it. Thank you. I provided some written testimony. I'd be happy to answer any questions if I can that you may have.
Are there any questions, members? Thank you
Thank you.
very much. Okay.
Madam Chair, thank you for the opportunity to be here, and the committee members. I am Pastor Dave Welch of the Texas Pastor Council Action, and I'm from Houston, and so I'd like to just address several different things, both in regards to our Houston effort. I was very much involved in that, and brought on Andy as our legal counsel in that matter. Has also worked with pastors and churches in Plano, as well as in El Paso and San Antonio and other cities where these issues have come up regarding initiative and referendum. And one of the things, before I go into this, and I did provide some written testimony for your benefit, I'd like to respond just in a couple issues and follow up to what Andy stated earlier, because this is very important for us to understand what Peggy just stated as well. The burden, when we, the citizens, were denied the right to vote on this, our choice was to either just give it away or step up and have to hire legal counsel and go up against the legal department of the fourth largest city in America with 80 staff attorneys, and they brought on 3 of the largest law firms in America doing their work pro bono against us, 15 lawyers in the courtroom against R1. It was our David and Goliath battle. That's the kind of scenario that is often the case. The ballot measure and the drainage fee or rain tax issue Andy talked about, one of our pastors was a lead plaintiff in that lawsuit as well, and our churches were involved in that issue. Again, deceptive ballot language, forcing the citizens to take action, and then going through 4 years of litigation, and that litigation being successful, and the city still refusing to comply with the end results of that litigation. So there's some dynamics here in terms of the citizens' remedy on the side of legal expenses that really does need to be looked at very, very carefully. And but you've heard really most of the things I think that have our recommendations as well. Number one, because of the things Andy described and has elsewhere, a template is a very simple fix, and we do recognize. And the thing we put in as Representative Laubenberg's bill last session addressed is that the template of a city should be required to either use one provided by the Secretary of State, or in the case of Plano, where there's a unique situation under state law because of that provision, and the city having multiple counties, that county field be included, then the city should then be responsible for creating that template for their municipality. It's not that complicated. So the issue is, it's a very simple fix that makes it accessible and easy for the citizens. And as was pointed out, let's put some real time in this too. In Plano, this ordinance was adopted with very little advance notice, going into Christmas season, and that particular issue, they were very well aware that much of the citizen opposition to that would come from the churches. Well, guess what December is for churches? That's a little busy time. And so between the holidays, end-of-year activities, and a 30-day timeline, no matter what, even if there was adequate information given that there was a flaw in the petition, there's almost no time to try to remedy that and catch that along the process there. So there's some things that play out strategically here that we also say the 180 days is very reasonable. And anything less than that, materially, in our opinion, is designed to raise the threshold to almost impossibility for citizens. The other thing I'd like to point out in item number 2 is, just take Houston and Dallas, for example. And by the way, initiative and referendum are 2 different things, as we well know. And cities may say, and Houston did, Plano, well, citizens do this all the time. No, they don't. They don't do referendums all the time. it had been 20 years since the citizens even attempted a referendum in Houston. And so really there was no institutional knowledge in any of the citizen groups in many ways, and so we had to dig fast and come up with this information. But the thresholds, as was pointed out, Houston is a registered voters just under 1 million in the city of Houston. Dallas registered voters are about half of that, as the population is in both cities. So Houston's about 2 million, Dallas about 1 million. Our requirement of signature threshold for the city of Houston was 17,269. It was based on a 10% of the highest mayoral voter turnout of the previous 3 elections. The city of Dallas, their requirement was based on 15% of all registered voters. Okay, you see the difference there? So in a city half the size, the city of Dallas, to do a referendum, had to gather 2.5 times as many signatures to qualify. Does that make any sense to anybody? So the citizens of Dallas are denied the same standing of access to a referendum on that basis.
Is that
frankly,
based
than
on their
Houston.
charters?
And that's based on their charters. That's correct. So certainly the charters can be amended, and we recognize that. But when you look at the reality of how difficult it is to amend a charter, to get the signatures, to do that, we know that the cities always oppose this. City councils could have made these changes voluntarily long time ago, and they don't. Because in most cases, regardless of, this is, again, take all the personalities out of the equations, a referendum is the citizens telling the city council, we don't like what you did, and we're going to repeal it. And that's not a real positive nature. And frankly, what we run into is the question of, in our case in Houston, the mayor was an absolute advocate for the policy we were attempting to overturn. She appoints the legal counsel. Legal counsel directly answers to the mayor. And what we found is we had a hostile legal counsel coming from the city. And that isn't the case in every situation. Certainly I don't believe it's the case in Plano. But the reality for the citizens is there's really very, very good reason for every citizen in the state of Texas to have equal standing in the law, to have equal right to vote. So the standards and the thresholds, just as have been applied in city charter requirements across every city, home ruled city, they should be the same for initiative referendum as well. And to me, that makes sense. And one other thing I would like to add as well, as part of our experience in this, is in the city of El Paso. And this is another element that overlays into election code, because there was an ordinance that was passed in the city of El Paso. The citizens gathered signatures, put it on the ballot, and actually reversed that ordinance. Then the city council and the mayor, some period of time, reintroduced the ordinance and passed it again. So some citizens began the process for a recall petition against, I think, the mayor and a couple city council members. So it's a recall petition. What happened then was, and they were, by the way, gathered an adequate number of petitions to qualify that, but the mayor filed a lawsuit against the citizens and actually began the process. The local district attorney began investigating possible felony charges against the pastors under this statute because, frankly, and what we believe adequately in the subsequent litigation, and even a letter by the previous attorney general indicated that the courts erred in their application of this statute, but they did nonetheless. And in section 253.094, under this corporate contributions in recall elections, the courts applied the act of gathering petitions as a political contribution. Okay? And in this particular statute, it says you may not make a political contribution in connection with a recall election, including the circulation and submission of a petition to call an election. So these, frankly, what we believe, rogue courts over there interpreted that, first of all, it made signature gathering a political contribution, which does not conform with the definition of political contribution in state law, and then said that, then applied that to the actual act of gathering signatures, not the expenditures, and then basically drug this pastor through the courts for 4 years, and finally, out of just sheer fatigue, settled the lawsuit for $400,000 for simply gathering signatures in a recall petition.
The pastor paid?
The pastor had to pay. And so what we're saying is that statute needs to be clarified. Frankly, Section B should be stricken entirely. We believe it's, frankly, our attorneys have said it's a violation of Citizens United. But at the very least, we believe there should be very explicit language to clarify that the act of gathering signatures by a 501 recognized Texas nonprofit, such as a church, is not a political contribution under this statute. And that protects the act of signature gathering, because that is, again, the process should be protected, not the outcome. And so we have a concern about that, because that's a very real situation which did happen here as well, which we believe requires some remedy. So that's, I guess, the nexus of our concerns. I would affirm everything Andy said, right with him on those issues and concerns as well. And I think that's all we've got. Thank you.
Excellent. Rep. Schofield.
Well, we've been talking all morning about the idea of having templates and having a standard form, and I'm glad to see that somebody finally mentioned the fact that our chairwoman actually had a bill to do that. Got it out of this committee 6-0 with one absent. I hope I wasn't absent.
No.
And it would have made it to the floor, except by the time it got said, it was too late. But
You must have signed on too.
That's right. I was in favor of it, so it didn't get said. But we have been working on this, and hopefully we'll all continue to. So thank you for bringing that up. I feel we're missing not having said so earlier.
And the idea is you're not complaining about what you have to do, just understand what you have to do, right?
That's right. It should be just
And
full disclosure, make it clear
make
and
it simple,
accessible and
make it
easy
clear.
and uniform.
And reasonable.
Yeah.
Mhm. I understand. Thank y'all for coming. Thank
Actually, I do have one more question.
Oh, Schofield. Yeah.
You pointed out in El Paso that they went after the churches for making a contribution as a corporation by the mere act of gathering signatures. To your knowledge, has any other city in any other part of the state gone after any entity other than a church for a corporate contribution in the gathering of signatures?
Not that I'm familiar with, but I'm certainly not going to say that I track everything in that vein that's out there, but I do know that this was unique in our experience with any of our churches and any of the things they've participated in anywhere in the state.
I mean, it's extremely disturbing to me that, number one, somebody would go after somebody for expressing their free speech rights when they're not making a contribution of any money. And secondly, the targeting of a church. So, and we've seen this before. We saw it in Houston with the rain tax. We thought this is the way we can tax the churches, until, fortunately, churches of the proper persuasion prevailed upon the mayor that might not be a good idea. But we need to make sure that the state is not using its weight to go after people's religious services and their religious houses, and that's something that we really need to take a strong look at. Thank you for bringing that to our attention.
Yeah, because that's obviously a major suppressing factor of any church anywhere considering, participating in that act of signature gathering for a recall election, which should be their duly constitutional right.
That is chilling. Thank y'all very much.
Thank you.
Okay, that concludes this charge, members. We'll move on to charge number 3, to evaluate options to improve the transparency of local bond elections, including but not limited to the current processes used to educate voters about how tax dollars will be spent, the time of year bond elections are held, and the description of bond proposals on the ballot. So with that, I want to first, NFIB, National Federation of Independent Businesses, could not send a representative here, but they submitted a letter, members, and I think y'all each have it. So I want to point that out with their recommendations and their positions. All right, so our first panel will be, again, Mr. Bill Longley, the Legislative Counsel for TML, and Steve West, Mr. Steve West, the Chief Financial Officer for Georgetown ISD. Thank y'all for being here. And again, it's, informational, and how can we make things better if we need to?
Sure. I'll go ahead. Bill Longley, Legislative Counsel with the Texas Municipal League. glad to be back. Y'all may be getting sick of me at this point, and I'll try to keep it pretty short here. To address what's in the interim charge, the first portion of that was related to the current process used to educate voters about how tax dollars can be spent. There have been a few pieces of legislation that have passed the last 2 sessions, respectively, that have gone a long way towards increasing transparency with regard to local debt. In 2013, Senate Bill 637 required cities, when they're holding a bond election, to include various types of financial information related to that, both that bond and the amount of outstanding principal and interest and outstanding debt. Requires the city to put that up on the website if it has one, requires the city to post it in 3 public places, and most notably requires the city to put all of that information in every single polling place that's used for that bond election. That was it. That passed in 2013. Last session, y'all, I don't recall if the bill came through this committee or not, but there was a House Bill 1378 that passed that requires debt reporting, annual debt reporting. We supported that bill, and that now is in the process of being implemented, requiring most of the same sort of financial information related to tax rates and total outstanding debt to be reported by cities and counties and schools, I believe, every year. And the city has to put, from the city's perspective, city has to put that up on the website, city's website every year, has to also, has the option, let's say a city doesn't have a website, can send that into the comptroller. Comptroller compiles all that information, puts it up on the comptroller's website. So those are a couple of initiatives, the last few sessions that have passed that have greatly increased transparency with regard to local debt. Another aspect of the charge refers to the time of year that bond elections are held. Under current law, a city could have a bond election on either uniform election date, assuming, I'm thinking of the May date, assuming that the county is able, if the city contracts with the county is able to put that on and provide machines and all that. But theoretically, a city could go to the voters on either the May date or the November date.
Well, now I have a question on that one, because I had a city that held a bond election on a date that wasn't one of the uniform dates. And I'm not quite sure how they did that. But they
Was it
did.
recently?
Yeah, like this year.
I don't know. I don't know how that, I mean,
I may come talk to you about that.
yeah,
Find out.
I'd be happy to look into it. I'm not sure.
I am totally confused.
There's some specific set of facts where maybe a court require. I don't know.
No,
Okay, well.
I don't know. But
yeah.
I'm just saying, it happened.
Yeah, well.
And that's why I think, we're trying to figure out,
Yeah. As a general rule, at least my understanding is that it'd have to be on a uniform election date. We've seen proposals in the past. I think there may have been a bill last session, and I know that the issue has been studied in the past to move all bond elections either to the November date every year or the November, I guess the even-numbered November date every 2 years. We've opposed those proposals in the past primarily because we value some sense of flexibility for cities to be able to go to their voters on either the 2 election dates that exist currently. At one point, maybe 15 years ago, we had 4 uniform election dates. We've now gotten that down to 2. We would like to see both of those options open for cities to go to their voters on debt, primarily because cities see themselves as partners with the state. And if you have these big infrastructure projects, public safety projects that you need to get the ball rolling on in response to the explosive population growth that we have in the state now, we think to retain that degree of flexibility to go at the very least either May or November makes sense, because, for instance, if you had all bond elections could only go before the voters in November of even-numbered years, you potentially could have some issue come up in a city and the city have to sit and wait on it for 2 years. And as y'all know, a lot can change in a city, including population, within a 2-year time frame.
Vice Chair Goldman.
Yeah, quick question. Would you agree that, let's take 3 election dates. Let's take a primary date, which for us is in March,
Right.
a May date, and a November date. Wouldn't you agree that history would show that there are larger turnouts, obviously the largest turnout in November?
Absolutely.
Second largest would be primary, and the lowest turnout would be May?
I think that's probably accurate.
So why would you take the position that the least amount of voters that show up would be beneficial to vote on any bond election?
Well, I would say that it's beneficial to either be able to go at the November date where there is a high turnout, or at the May date, because that's an option for a city to go to its voters to say, here's
Yeah, but
whatever
historically
issue.
it's the least amount of turnout.
It is, although it doesn't have to be that way. You
No,
know, if-
agreed, but
Yeah.
it's human
It is.
nature, it is. It's
It
the
is.
reality.
Yeah.
So would y'all take a position that if we move, say, a bond election to a uniform primary date or the November date will be better than the May date?
Potentially. I can't say that we would oppose that. I think to be able to retain a couple of options to be able to go to the voters would be
I mean, obviously,
is
yeah,
important. Yeah.
going to the voters is the ideal thing. But in
Right.
reality, the most people turn out in November or the primary, and the least amount turn out in May. And if
Sure.
you're going to go and
You're
issue
right.
debt, the more that have a say in it, the better.
I agree on the turnout question, no doubt about it. The other aspect, if somehow something came up and the committee and the legislature were looking at limiting dates, moving it to one date, either every year or every 2 years, I think what you would see is cities have to build roads. They have to do water, sewer projects. They have to do all these things, especially these very fast-growing communities. You might see cities going more towards things like certificates of obligation or other debt instruments that don't require an upfront election, if that's the only option a city has.
Okay, you said the magic word, so I'm going to follow up on that. Certificates of obligation.
Oh,
My bill last session on certificates of obligation. Actually had a city councilman say, after a bond election was held and the voters voted against the bond being passed, a month later, the city council issued certificates of obligation to fund the very thing that the voters voted against.
That's interesting that I had not heard of a city doing that.
Mm-hmm.
It may help that House Bill 1378, which passed last session, prohibits that now, so it cannot be done. And I remember your legislation on that, and we worked with you on it, and we appreciate the ability to do that, and we didn't oppose it.
Right.
So, yes, to your point, though, that if a city did that, they can no longer do that because of 1378.
So what's y'all's view of the certificates of obligation? Again, cities and counties have an opportunity to pass major debt without going to the voters to issue such debt.
And it goes back then to a petition requirement. You don't, the way the CO statute is set up, you don't have to have an upfront election like you do on, say, a general obligation bond. But, there's a petition requirement to be able to petition to hold an election after notice is given for the CO. What we've seen is that a lot of cities, in lieu of issuing a revenue bond, let's say for a water sewer utility, instead have used certificates of obligation because they get a much better rate. And there's examples of cities saving tens of millions of dollars by issuing COs instead of revenue bonds for those projects. And by the way, revenue bonds don't require any election either because it's paid through utility funds. So we think that COs do serve a very valuable purpose. And if there's transparency measures like you had in your bill last session to get the word out there, we're happy to look at those and
But you do agree
potentially change the
COs are cities issuing debt?
Oh, yes. Absolutely.
And basically not a vote by the citizens when that debt's being issued?
Not a required vote, that's right.
Okay, thank you.
So yes, current process, time of year bond elections are held. The last one is the ballot language. And this has been kind of the line in the sand for a lot of cities and other local governments for a while is how much language is put on the ballot. And there have been bills filed the last few sessions that would require outstanding debt, total interest, total principal, tax rate information, all to go on the ballot itself. We've opposed those measures. We've, again, supported many other transparency bills, but we have not supported those. The reason why is, number one, with the bills that have passed that I mentioned already the last couple sessions, any voter, when they go into the polling place, have access to every bit of the information that's proposed to being put on the ballot itself at every polling place on the city's website. It's readily available, including within the polling place. That's issue number one. Issue number two is what we're concerned with is when you put a snapshot of information on the ballot, I would say that transparency in some of those instances isn't being served if you're just presenting a very limited amount of information. And I'll give you, an example of Mr. Taylor, when he was just talking about ballot language in a different context, mentioned that when you have that ballot language go before the voter makes a judgment very quickly on that ballot language. You know, they don't have all day to sit and sift through information when they're in the polling place. And so what we would be concerned with is if you just have ballot language that says, you know, here's what your tax rate's going to be, here's what, the city's total outstanding debt, maybe it says $5 million. Well, $5 million to me or to most people sounds like a whole lot of money, but that doesn't tell you anything about the city's ability to repay it, or the tax rate that would be imposed if you paid as you went instead of issuing the debt, or maybe you have X amount for outstanding debt, what you're getting for those services. So if the goal is to educate voters within the polling booth itself, one, we think they have some access to that already under current law. And two, if you want to be transparent, I think it would be our position you put as much information out there as you can instead of just a little bit. And I've said this before, I probably said it last year before this committee, we could put the city's comprehensive annual financial report on the ballot, and we would be more likely to support that than just a snapshot of information.
Rep. Fallon.
Question. Thank you for coming and sticking around.
Sure.
I just wanted to share with the committee and with the folks that are maybe watching, I was on a city council in Frisco for 3 years, and Frisco has been, I mean, not every year, but almost every year, the fastest growing city, not only in Texas, but in the country. And this is one of the reasons why I'm all for having bond elections only in November of even-numbered years, because historically, that is the largest turnout we get. I would like to put them before any partisan elections so people can see that. And the reason being is Frisco, as rapidly growing as they have been, they've only needed 3 bond elections in the last 15 years, in 2002, 2006, and 2015. So you would think that may need something, spur something, like you talked about, but it didn't, because the planning of it, and each one of them was about $200 million. I think the last one was $267 million. And in fact, the one from 2006, interestingly enough, almost 12% of that hasn't even been spent yet. I think it was $198 million, and they still haven't spent $23.5 million of it. So that allays my concerns about not having the ability to do it every 2 years. I think that's actually plenty, and I think this is one of the poignant reasons that proves it, that over a 14-year period they only needed 3. Mm-hmm. So it's not something that comes up and you say, oh my God, look at this policy, we need a new bond. And if the cities knew that they could only do it in November of even-numbered years, every 2 years, they would simply plan accordingly. I just haven't seen any instance where you would need something, spur of the moment. So that's that. And as Representative Goldman said, when you're talking about this type of money too for a city, collectively $650 million, I don't think it can be argued that the more citizens weighing in, the better. I really do. That's one of the things that I don't want in a city, in our particular case of 160,000, to have 3,000 or 4,000 people deciding on what everybody else has to pay. Now, granted, they all have the opportunity to go vote, but we know what the realities are as well. So sure. I would be all in favor of doing it just in November. But thank you.
Rep. Reynolds.
And Pat, I would probably agree with you, but when I talk to, like, my local mayor, they always say that don't take away our flexibility. You know, you guys talk about local control and then you take it away. So every time I suggest that the larger voter turnout is in November, they say, well, you know, let us decide. You know, we think that it should be left to the local. So, you know, I understand your position. I agree with you, but then again, it's hard to argue with the local control in terms of letting the cities decide if they want to have it in May or November, because our municipal elections with one of the cities that I represent is in May. And they said, well, why shouldn't we be allowed to have all of our bond initiatives at the same time, as well as our school board is in May as well. So it's kind of hard to argue against the local control aspect of that.
No, and if I can respond, thank you, Representative Reynolds, for bringing that up. I'm all for local control so long as the locals don't get out of control. And you know, the cities and are not separate states. Like you know, we have 50 independent experiments in democracy as a country, but cities are a part of this state, and it's very different. They don't have the governors per se and what have you. What I'd like to see, quite frankly, is I don't see any reason personally for May elections. And we can debate this, and not everybody agrees with that. But we had too much voter fatigue, for instance, this year, and where I hang my hat, we've had 5 elections already, and we're going to have a 6th one, believe it or not. So we had your primary runoff, May runoff, municipal runoffs. Then we had a TRE, a taxpayer ratification election, held in late August, and then we're going to have the November election. And then they move the polling sites all over the place. That is a form, I think, of voter disenfranchisement when you do things like that. What I'd like to see is, more uniform sites. And if everybody knows you vote in Texas in March and in November, they're going to. I think that the turnout would actually increase. And again, that's kind of a separate issue, but at the end of the day, we're also elected by the same people as well to sometimes oversee this stuff, and we're involved. And I think it's very hard to argue with the fact that we know the most people vote in November of even-numbered years. And to have people weigh in on these important things, particularly on bond elections, would be awesome. So thanks. Sorry.
Madam Chair?
Who punched?
We'll let Reynolds.
I turn out.
Israel?
Oh, you turn out.
Schofield.
I think it goes back to what one of the witnesses said earlier, which is the ultimate local control is the voter. And we had mud elections that have been held in people's garages, sometimes with, when they run out of ballots, they rip off a corner of a piece of paper. I think in order for an election to really be a valid expression of the voters of the area, it needs to be held when people know about it and tend to vote. And I think the November elections is when that happens.
Well,
Vice Chair.
thank you. And I might add, cities and counties can sit there and issue debt and have elections to issue more debt, and of course set those elections when it's more favorable to issue that debt. They can issue certificates of obligation for more debt. And my concern is yes, I'm all for local control too, but when you issue so much debt and then they can't pay the bonds on that debt, who's it fall to? And it's going to fall to the state. And that's where it's our opportunity to come in and wake up the citizens of the state and say, your issues, your counties, your ISDs are issuing so much debt that they're not going to, you can vote your elected officials out of office, but the debt's still there. And then what happens?
Okay. Thank you.
Thank you.
I'm sorry. Pardon me.
All right, that was simple. I appreciate it. Yeah.
You
questions?
thought you-
I'll answer any questions you have. Yeah, thank you. I appreciate that very
I'm
much.
sorry.
That's okay. My name is Steve West, and I'm the CFO of Georgetown ISD, and I'm here representing the Texas Association of School Boards. Madam Chair and committee members, thank you for having me here today. I'll just start with a little conversation about, we did have a bond election in November. As far as I would echo what my friend here said about we don't have a problem with November or May or just the flexibility for election times. And I'll go into that more in just a minute as to why. But just to give you some idea of my experience in Texas public schools, I have been in places like Pasadena, which is a rather large school district. I was in Allen for 12 years. I'm now in Georgetown. I I have seen a lot of bond elections over the course of that period of time, and have been involved from a staff position in many of those. As CFO, of course, I'll be involved in the kind of the financing side of it, and looking at, not only the ultimate sales of bonds and so forth, but just, the planning cycle, what it takes to get those bonds done. But just a little idea about my experience with how you communicate. Our communities support public schools, and we appreciate that. They won't support public schools if we don't continue to do things that build trust, and transparency is a part of that. We had a bond election of $160 million. It passed with about 60% support. The committees that represented citizens of the community, a cross-section of people in the community, were selected, asked principals and board members to bring names to the table, and we had about 52 individuals that represented our community. There were parents, there were county representatives, even elected officials in some cases, retirees, community volunteers, real estate agents, local business leaders, just a cross-section from all aspects of our community. Over a period of about 6 months, there were 6 meetings held to kind of gather, their role was to gather the information and bring it back to the board with their recommendation, ultimately in time for us to actually be able to call the election, I think in August of that year. So they had their own leadership. We did have an outside consultant that helped guide their process so they would not flounder and so forth, but they had 4 individuals who stepped up and said, yeah, we'll take the leadership role, and they led their meetings. We served as a resource to that committee. And of course, we've got a lot of information that we can provide, whether it's enrollment growth or whatever. We use an outside demographer to come in, and for about 3 or 4 years, our enrollment was pretty flat in Georgetown, and then all of a sudden, boom, it started really cranking. Leaving us to wonder where we're going to put the kids based on where they're coming from into our community. And we have exceeded our enrollment growth so far that the demographer has presented to us. So it triggered our need to have to call an election ultimately. We're not unique in that. And frankly, it is, from my perspective, we need the flexibility to have at least a couple of times a year that we can call those elections. We have no problems with May or March or whenever, when we have large voter turnouts. We do appreciate active citizenry representing themselves and how they vote in our communities. The board accepted the CAC recommendation and, of course, began the process of called the election and so forth. And then as far as communicating to the community, we started with a district website or a dedicated website for the bond information. We had a tax calculator so voters could kind of gauge what it would cost them. We were telling them at the time it would be 5-cent increase. It ended up being about a 1-cent increase in the tax rate for their bond side. 20 meetings with civic community groups, chamber meetings, Rotary clubs, PTAs, all of the normal groups, citizen groups and community groups. Sun City is a big part of our community, and so we have very good representation, a very supportive group of people in Sun City, and so a lot of meetings were held there. Probably 25 community meetings on top of that, including 17 campuses. We had interviews, we had social media, we had press releases, videos, tours of the community facilities, and mass flowers. Just some idea of how we try to reach out to the citizenry. I would like to say that the voter turnout was extremely high in terms, it was even November, but I would always like to see higher voter turnout, frankly, because I believe that represents how people, even though we had 60% favor, I think I would love to see the number go up in terms of how many people get involved in the election process. I think it's a problem in every election process.
You know, the voter turnout percentage was? You got 60%.
It was 60%. Well, as far as the total population, I don't.
Yeah, I know you got 60% of those who turned
Yeah,
out to
that
vote.
voted in favor of the
How
measure.
many turned out to vote?
Oh, boy.
Do you have any idea?
I
Based on,
I don't remember it. I didn't grab that number before I came. I
That's okay.
apologize. I should have had it. I thought of it as I was sitting here talking. That would be a good question. I will say that it wasn't as good as I would like to see.
Madam Chair,
voter
have-
turnout.
Oh, Rep. Israel.
Thank you, Madam Chair. Mr. West, I have a few questions for you. How long have you been involved as a professional in school finance?
About 45 years.
Oh, my God.
Yeah,
That's a lot of time.
a lot of times.
I can't remember when you were at Allen.
I did, yeah.
Yeah, I didn't mean that in a bad way. I meant that in a supportive, respectful way. But how much did it cost the city of Georgetown to do your last election? Do you know? Roughly.
You know, we have it with a joint, it's a joint election, so that's always a nice thing to have elections
share the
gathered
cost.
together. And so I think our portion was about 30,000, roughly, our
Okay.
portion.
That's good. Take some sting off when you can share it with the county and.
Absolutely. Yeah, I
Oh,
love
that's
that.
right. When you do it in
Yeah.
November, you share it. If you do it in May, you would be on your
Well,
own.
we have, there are other elections that happen, not necessarily every May, but yes.
You can share the cost of the machines, the
Yeah.
poll watchers, the
Yeah.
ballots. So I know that Georgetown is growing tremendously,
Right.
as many of our medium-sized cities are. The state of Texas hasn't given you any additional public school funds, so you have to locally find the funds and support your school system. But I'm also recalling that last session, we, the legislature, allowed our institution of higher education to borrow $3.1 billion for their institutions of higher education. What we're talking about is, how to conduct these elections and be transparent. Do you think the state should be held to some standards in regards to transparency as you are?
Well, I can't really speak to the state. I can say that probably it's good for every entity to have transparency. My job, the success of my job relies on my integrity, and I can't do that in a vacuum. I can't hide what I do. I don't want to hide what I do. I prefer that people see what I do. I worked a long time to protect that, personally protect my integrity. So it's good as I work in a governmental entity that I portray that. I want that. I want transparency, and I want the public to feel comfortable. I think I've been successful in that personally, but I think it's good for any entity, state, local, city, county, to be open and transparent.
Well, thank you. I think you laid out for us the challenge at the local level for outreach, being transparent, and running a nice election. Thank you very much for your time.
Any other questions? Oh, Rep. Fallon.
Thank you for coming. I appreciate it.
Oh, you're welcome.
So I had a couple of questions. I mean, we're all products of our own little worlds that we live in.
Sure.
So I haven't observed Georgetown. Everything you put in here it seems great. What I have seen is some other districts maybe not doing it quite as transparently, unfortunately, as we would like to see. So I just wanted to, as a member of TASB as well, that just wanted to chat with you about some of that. Do you know if Georgetown ISD has ever done a bond election in an even numbered November year? Offhand?
I couldn't tell you. I know they've had like 3 bond elections in the last 10 or 12 years. I think 2010 was the last bond election before the 2015 bond election, so that would have been an even number.
And they did in November?
Mm-hmm.
Yeah, I think that's awesome. Yeah. I mean, that's tremendous. You don't unfortunately see that more as the rule. It's usually an exception.
I tell you what drives the whole issue. From our perspective, we're not sitting there. We're sitting here thinking about we've got kids coming to school, and we know that if our demographer is correct, we're going to meet certain problems in certain schools because they're going to just kind of fill up. And we do adjust our boundaries to try to accommodate that. The geography prohibits some of that.
Within the district.
Within the district, yes, ma'am. So we try to work our way out of a problem so that we don't have, because we know that to go through the process of even having a bond election is an exhaustive process. It takes a ton of effort by a lot of people, obviously, and it involves the community. So the lead time on that, in our case, we used about a year. We started thinking about it in a year for the election, and then, of course, we called the committee together in, I think it was February or March. We'd loved to have had them in January, but we were just scrambling to get things done. My point of all that is this, that what the driving issue we had was, if the kids come to our school district, where are we going to put them? And so sometimes that's building an expansion on a given spot. We have a lot of things to the west of I-35 that, like karst and other issues, environmental issues that keep us from expanding certain campuses. So we have to put it where the people.
But you try not to overload one area.
Right. It gets. We try to keep campuses. We have some small campuses, but we try to. It's kind of the sweet spot is between 650 and 800 kids. Would be where we'd like to be in terms of the number of kids in elementary school. A little bit higher for middle schools, and of course our high schools, almost 2,000 kids.
Sir, how many students do you have?
We have 11,400 kids this year.
See, and I'm reading here that you reached out to community with meetings and videos and things of that nature. Was there a PAC formed for the bond?
After the bond election was called, yes, sir.
Was there a PAC formed against the bond?
Not that I'm aware of.
Okay.
Yeah.
And that's one of those other things that you see there, because it's a challenge for you all to have both sides there if there's not another side, let's say, organized. You really can't. And that's the ideal scenario, I think, in a perfect world. Waving a magic wand is you do your reach out, and if there's an organization that is identifiable that's against, have that open and honest discussion, because if the need is strong, you're going to come out on top anyway. And if there is an issue, then that's something that the citizens will be well informed in seeing, because when they're getting it from one organized side and one organized side only, are they getting a full picture? And you try to provide that for them, but it's
our
tough.
role is to inform. We don't, not advocate for whatever we're doing, but I do understand what you're saying.
And that's my concern too, is the role of informing and advocacy is a fine one. Because
yes, sir. I agree with that.
As a state, we say that you can't advocate as a school district, and yet even in the handout you gave us, there's the need. The video explained the need for a bond fund.
Yeah.
So that could be construed as advocacy, and I know it's tough.
Yes, sir,
nonetheless.
I understand what you're saying.
Because we had a taxpayer ratification election in the area I represent,
Yes.
and I think one of the things that ultimately it failed by about 17% was specifically because of when they called it. They moved all the polling sites. I mean, people started to see that and feel like they're trying to just throw this out, and it would kind of pull the wool over our eyes.
Right.
It wasn't, I think, respectfully, and you had nothing to do with it, but it wasn't transparent, and that's what we really want. And they also, the same district did 2 years ago, they did rolling polling in a bond election, huge bond package, $775 million. In fact, one of the smaller school districts that I represent said, "What? Oh my goodness, are they building a spaceship?" But they had rolling polling where we normally have 4 or 5 polling sites, and suddenly we had 49 additional polling sites that were only there for 4 hours, and only when they had an open house at the school to bring more parents in, which were targeted voters. And then when you saw the results, yes, they were targeted and it worked. 81% of the early voters, which is where the rolling polling occurred, voted for the bond, but on election day, 60% voted for the bond. So the bond would have passed anyway. That's why when you said 60-40, that is actually indicative of an honest and fair and open election and a bond. In that 50s to 40s, 60s to 30s. But when you have 81 to teens, something's going on there, and that's manipulative. And that's really what we're after here, is just if you have an open, honest, fair election, the result's the result, and everybody feels better about the result afterward. Not the Putin-esque stuff that we were
I
seeing.
think exactly what you were just saying. And what you described, y'all went to the community. You went to the chambers, the Rotaries.
If we haven't been, we've gone, yes.
Everywhere.
And
you gave folks a chance to see what was going on. And so I kind of suspect that your turnout would be probably higher than
It still
average.
wasn't as high as I'd like to see. It's disappointing
So
when
I'm-
you have any election.
Well, that's any
And you don't
election,
get people
But
participating.
if you have 2% of the voting population turning out, that's pitiful.
Madam Chair.
It was higher than that.
I know that. I
But
don't
don't remember the exact number.
But if you have, even 20%, that's actually considered good. I mean, we do everything trying to get folks to vote,
I know.
so let's not do things to
Yeah.
discourage them from voting.
Yeah, I would encourage if there is a bond, or in a bond, or if there's a TRE or what have you, that has an organized, packed opposition, to try to reach out and invite them to these kinds of forums, because then you're fully covered, and then it is true transparency.
Right.
Yeah, thank you.
Yeah.
Vice Chair Goldman.
Thank you. I'll answer the questions for you, Madam Chair. 5,825 people, 60% voted for it. 3,900, 40% voted against it. 274,227 registered voters for that election. 30,959 ballots cast total in that election, not for the bond.
Right.
So roughly 9,725 people voted for it. Turnout was 11%.
11%?
11.29.
Better than I remember, but still not.
Yeah, but Mr. West, I have to commend you. I mean,
Yeah, you did everything you
went
could.
to the community. If you did everything that you said in here, and I
Yes.
trust that you did.
Yeah.
You went to the voters. You educated them as best as you could. Right, you can't force people to go vote, but you educated them.
Yeah.
And if I can take what you did and put that in my certificates of obligation, Bill, next session.
Well, I haven't issued COs for a school district. I don't know how many districts do, but, I think I was in Pasadena, Texas over 25 years ago when we issued COs. I know at the time I was in Allen, we did not issue them.
School districts can do COs?
Yeah, you can, school
Yeah,
districts for equipment, for
Oh,
buses
wow.
and so forth, yeah,
Right.
things like that. But anyway, yeah, the ballot language was the other item that I wanted to just speak briefly. I'll just kind of echo what I heard my colleague here say. I just believe that voters need to be educated, very educated, but not at the ballot box. I think it just complicates the issue, and I'm not afraid of that. I think we will get success. I'm confident in our process, but people walk in. One of the early voting spots is in our building, so I watch lots of people walk in, especially from Sun City. People that are actively they actively participate in the election process. I love that about them. And they'll come in, and some of them are,
The seniors.
Yeah, the seniors.
Right.
I represent that group, as you can tell. But the bottom line is, I don't know of any other ballot language, and I may just be ignorant, but when it comes to voting for positions on a ballot, like people or propositions at the state level, where there's a ton of information that you're trying to evaluate right there at the time that you make a vote. Yeah, I think that causes some problems. That's just my opinion, but it represents the opinion of a lot of folks that I'm representing here today with TASB. So, all that said, I just thank you for the opportunity to come and speak to you. This has been a good experience.
Madam
Thank you.
Chair.
Yes, Rep. Schofield.
First of all, I want to commend you for some very refreshing comments about public participation. I sat in the back of the room in this committee over a decade ago, and 2 straight sessions heard school board members come in and say they don't want to have elections in November because all those uninformed voters who don't know about their issues and may not vote for the bond would come out. And so I was glad not to hear things like that. Mr. Longley, I don't want to leave you out. One of my colleagues
Thank you.
reminded me that, and this happens as well in my area, in May elections, often during early voting, we'll have to go to several different places to early vote in the city election or the mud election or whatever other election that we have going on. I think I had 3 different buildings I had to go to last May, or the last even-numbered year. Is there any objection on your organization's part if we move toward consolidating early voting in May elections and have more of a contracting with the counties to run early voting for all the elections so that they're held, not in garages and not in 3 or 4 different places where folks can actually get out there and vote for whatever's on their ballot?
Probably not. I'll say there are a couple of issues that have come up in the past with regard to contracting with the county, and that was a couple sessions ago when Senate Bill 100 passed. It basically forced many counties to say to cities for the May date, we can't help you anymore because the primary runoff is so close to the May date that we can't provide machines. So there may be it may be difficult for some counties and cities to work together on the May date.
And I'd like to fix. I had a bill to divorce our runoffs from the feds. The reason why we have to have our runoffs a million years after the primary is because the feds waited until after it was no longer a problem to find soldiers in the field because we have email to fix a problem that started in the Civil War by making us mail them out 45 days earlier. And I have a bill that would say if you don't have a federal runoff in your jurisdiction, you can have your runoff where we used to have it. And if there's a runoff for Congress, let them do theirs at the end of time. So we would free up our machines and be able to go back to where you could have voters who want to participate in their city election will see their mud on the ballot and be able to actually participate.
Sure. There's one other bill last session that ultimately passed. It was Representative Greg Bonin's bill, came before this committee, and I know that I don't remember all the specifics of it right now, but I know that bill related to early voting polling places and where, when you have multiple elections going on, and we worked with the author of that bill, and our concern as it was filed was you could have cities, particularly small cities, who would be forced to use county polling places, oftentimes outside the city limits, which we saw as a bad thing for those city voters. Instead of going to City Hall to vote, where they always have gone, if you live in small city, you have to then drive out to the county to vote for that in that city election, which we saw as a problem. It was that was addressed. The bill was
actually, it didn't really address the May elections because our office got multiple phone calls on the rolling polling. And we were told when we checked it out that it didn't apply to the May elections.
Okay.
So
I will state, I'm sorry, I didn't mean to interrupt. I was going to state, we did not use rolling polling.
No, I didn't.
Yeah, you know what? I wouldn't think you did. So.
When you have a 60-40 result, that tells you right there that you didn't
Well,
manipulate
we actually had
things.
conversations about it. But I don't know that it moves the needle. I don't know that there's enough circumstantial evidence that proves that it's worthwhile. Others disagree. My colleagues and
it certainly moves the needle in getting people to vote for the bond, but I don't think it's about fairness. And this example, and there was another one that we saw last session that was the same thing. Was a rolling polling in a sizable district, and they got almost exactly the same early voting result, 81-19. That Frisco did in 2 separate elections. So for me, that was enough to see that. But what I was telling people back in Denton County was, I wouldn't want the Republican Party to run the general election because after a while, you're going to start putting polling locations. It's just human nature. The Democrat Party would do the same thing, where it's going to be more favorable to you. You have to have that independent, party to do that. And just if I can, we had that issue with multiple voting sites for May elections. In 2009, you had to go to 3 different places to vote: city, school board, and then there was a special alcohol election. That is voter disenfranchisement. Absolutely. I don't know if it is a violation of the Voting Rights Act, but if not, it should be. We were able to fix it at the local level simply by asking the city and the school district to hold a joint election. It was an odd thing because we're in 2 different counties, blah, blah, blah. But bottom line was they held technically 2 separate elections in the same room. And you just had to walk across the room. You did have to register twice. But it fixed the problem because it was disenfranchising certain people. And I'm thinking about maybe something of counties of a certain size, perhaps, to compel that, the city. We just need to make sure that in May, you go one place to vote.
Williamson County has a wonderful way of doing it that they just started a couple of years ago, I think. It's new to me in terms of, I happen to live in Round Rock, but I work in Georgetown. I vote in elections for Round Rock in Georgetown because the county has worked together with the entities to come up. And if you cross counties, that's another issue.
Voting centers and
Yes,
throughout
right.
the county.
So I
right.
love that because I can walk down the hall of my own building and vote because we have early voting there. So.
Yeah, we do have a challenge when you have a school district or another entity that's within, or a city, in fact, that's in 2 counties, as we have in ours. But also to Representative Goldman's point, we had discussions as to where to put polling sites, the better, more visible area, like a city hall is what you mentioned. And we actually tried and wanted to do it in the city hall, and one of our bureaucrats said, "My God, we can't do that. People come into the library, well, then just go vote." Isn't that the point? You know, which really showed their cards in. We like it when only 3,000 people vote. We know who they are, and we can find them. We don't want 18,000 people to suddenly vote. And I almost, I got physically ill when he said that. I was like, gotcha. Yeah. That's why we need it here. But thank you. Thanks.
Thank you
All
so
right.
much.
Thank y'all.
Really appreciate it.
Appreciate it.
Okay, members, the last charge. We are rocking. Oh, my gosh, pardon me. We have one more panel.
Yeah.
I am kind of zoned out. All right, Peggy Venable, former Director and Policy Fellow, Americans for Prosperity, and Mr. James Quintero, Director, Center for Local Governance at the Texas Public Policy Foundation. Forgive me, I'm thinking session and we're ready to go home. Thank y'all for being here, and who would like to begin?
Ladies first. Me too. Thank you so much. Hello, my name is Peggy Venable. Thank you so much for inviting me to participate today. I really think this is such an important issue, and for the last 20 years I've been involved in talking about local debt in Texas, and I really appreciate the speaker issuing this interim charge, and thank you, Madam Chairman, for your leadership on this and the petition issue. According to the Bond Review Board, Texas is about $339 billion in local government debt. A lot of taxpayers don't know how much debt their local entities are carrying, in part because they pay taxes into numerous local taxing entities. And I think the more they know, the better informed decisions they can make at the ballot place. So I kind of went down what I found on the Bond Review Board website, which I find to be very helpful, and am constantly referring citizens to so that they can look up that information themselves. But certainly school districts carrying the most local debt at $117 billion, including principal plus interest because we owe both, and then cities not too far behind with $108 billion. We are here today to talk about what we can do to provide some safeguards or some better better methods to institute how we do our bond elections in Texas. And I have several. Now, I know that local governments are hesitant to want to put too much information on the ballot. As a taxpayer, I'd like to see included how much debt that entity is carrying, how much it's going, this new bond initiative will cost the average homeowner, not just the year, but over the life of that bond initiative, because even though there's $4.8 billion on the local November ballots in Texas right now, that doesn't include the interest rates the taxpayers would be paying for what of those that they approve. I think there's really one simple thing that could be done, which I think makes sense, and that is if it's going to increase taxes, call it what it is, a tax increase. Calling it a bond initiative, I think, and I have to say I have great respect for voters. But they're busy people. They're doing a lot of different things. And calling it a bond initiative and hearing local entities say it's an investment in your community and in your future, they think of a bond as an investment, and they need to just call it what it is. It's a tax increase. And so I'd like to propose that we start considering something really novel, and that is calling it a tax increase. I also failed to mention that I think also too many local entities will propose a bond initiative, and if it doesn't pass, they'll come back to the voters again within a year and ask for it again. Maybe in different terms. Maybe they'll divide it up, etc. My school district in Round Rock has certainly done that before. So I think that we should say that there should be a cooling off period. If it fails, you have to wait 2 years.
Okay, and is there any kind of wait period now? They could come back.
They can come back immediately.
A week later after it goes down.
Well, and the
If it
next
went down.
election date. That's my understanding.
Okay, the next election date.
Right.
You're right.
So I'd like to see at least there be some time that truly voters get fatigued and they know
Right.
that they can wear voters down. So I've talked a little bit about bond language. I know that I'll let James discuss that. I know you're going to talk about bond language. I understand you are. The uniform election dates, we've kind of discussed that. I think an alternative would be, and many times we're so disappointed when we see that local debt passes with 5 to 6% of the voters participating in that election. It has in the past been that low for some of them. To require a threshold that a certain percentage of voters have to have participated before the tax increase or the bond initiative could be enacted. Another would be how simple is this? That bond money should be used for the purposes that taxpayers approve it for. And I'll say I was first introduced to this concept that there's such a thing as leftover bond money that seems to be a slush fund for some local entities. When my own school district, Round Rock ISD, at a meeting I was attending, was discussing how they were going to use $36 million in local bond money. It was left over from a bond initiative, and they talked about it, as I've said before, like it's leftover meatloaf. Well, this is a lot of money for us as taxpayers. And they even had the school district attorney come up and explain, there's no prohibition against doing this. It's totally legal for us to use this money for other purposes. I consider it a betrayal of the taxpayers' trust. We were told when we were given a bond initiative that these are the projects we're going to do and this is how much it's going to cost. Thank you for saving us some money, $36 million, but that doesn't mean that money saved can be used for other purposes. I think it is a real disincentive for good government because there's almost an incentive there to jack up how much we're going to ask taxpayers for because we know we may not need all that money for these projects, so we can use it for other things that we may want it for because we, heaven forbid, we've already let those bonds. So I think that we need to say it should be used for the projects that were on the ballot that voters approved.
Did it ever used to be that way? It seems like at one time it had to be used only for what was on.
I have an admission to make.
And we can look that up too. I was just curious.
When I was first went to my school board meeting on this issue, I think I was surprised that there was no prohibition against using it for whatever purpose you want to. Some school districts have said we're going to build 3 schools with this bond money. Taxpayers pass it and they build 1 school, and they have leftover money.
Yeah.
So I think that's problematic, and it's a simple fix, I think. Let's see. And I also just pulled from a news article talking about, I hate to point out, but it was McKinney ISD, and saying that the additional $7 million will come from money left over from bond projects, and I highlighted that in yellow. Mm-hmm. And that's small potatoes, I guess, compared to what Round Rock was doing with their $36 million. Leftover money. Then I think we also should take a look at who is funding the pro-bond PACs. And I know someone previously, Representative Fallon, had suggested that those that may be opposing the bond initiative should be invited to events. Well, there's an extensive outreach the school districts or cities do in educating the public on these bond initiatives. But they're using our money to do it. Again, I'll use an example. My school district, when Round Rock ISD was floating a bond initiative, they had a video done talking about all of the wonderful things that could be done with this bond initiative. At the time, my daughter was in high school, so you could tell it was a while back. My daughter's now 28. But she came home from school one day and said, "Mom, we saw this video, in second period, and it was all about that bond initiative. Aren't we opposed to that? And then she starts talking about what all it said they were going to do, and she said, they said that testing is taking place in a closet. That's not a closet. And so she was really offended by this. She was a little surprised when I called the media, and we had 4 TV stations in my front yard and a ton of neighbors the next day to talk about that. But the fact is that our dollars are being spent to educate the public, really to be favorable for these bond initiatives. What is also happening, though, are these PACs are formed to advertise and promote the bond initiative, and too often we see the supporters of those initiatives are architectural firms and construction companies and others that would benefit from the buildings. And I think that we should say that if you support the bond initiative PAC financially, then you shouldn't be able to turn around and bid on those projects and financially benefit from those projects being built. That's my perspective on it, and I will put that before you. Also, I think it's a problem when the projects are bundled. Interestingly, I think school districts have had better luck when they're not bundled, when they don't say that we're going to build a stadium and 3 schools and an art center or whatever. When they do it individually, voters will be more likely to vote for them, is what I have seen. But it certainly is unfair to us as voters, and I've heard some school district officials say, well, we want this stadium, we need to put a school on there too so that we can pass this initiative more easily. So they bundle these projects together and then sell the ones that may be most favorable or easier to sell to the voters, and they get all the projects they want. I think they should be divided by project. Again, my perspective. Now, I will also, Representative Goldman, I have to mention certificates of obligation. I'm passionately opposed to those as a means of obligating debt without taxpayer approval. And here, the city of Navasota, I just found this recently in the media. It's just this month. And the reporter, I'm not sure the city said this, but the reporter says, a CO is one of 2 options for financing long-term debt for public works projects. General obligation bonds require voter approval through an election, whereas COs allow voters to petition for an election. We're allowed to petition if we want to oppose a certificate of obligation, debt that is not put before us for our approval. I would certainly challenge that word allow and say requires us, and that petition gathering process, as you discussed earlier today, it can be an onerous one. And I was, shocked in a recent Senate hearing when a businessman and former mayoral candidate Bill King went before the Senate committee and talked about how much debt the city of Houston has. I think I said $2.4 billion and $23 billion, but 4.2% of it had been voter approved. Only 10% had been voter approved. And so we know that there's some revenue bonds, but some COs in that also. I think that in concluding this, I'll just say that it really is important that we get bond election process, we get that right. Mm-hmm. That it's simply wrong not to allow voters to approve issuing debt. I will say that I am ashamed that our generation is leaving the next generation so much in debt. Local government debt in Texas is truly a legacy that we're leaving the kids, and it's not the legacy that most of us want to be leaving them. Bond elections can be more transparent and more information provided to taxpayers, so we are confident that that's debt that we truly are willing to take on and pass on to the next generation. Thank you.
Vice Chair Goldman.
Yes, thank you. Thank you very much, Mrs. Venable, and I look forward to working with you next session on my certificate of obligation bill next session as well. And just to be clear, my bill did not end cities and counties and ISDs from issuing certificates of obligation. All it did is say you need to notify the public more, do a better job of notifying the public, and yet we still receive great opposition from all those entities.
I saw that, yes, sir.
Yeah, so we look forward to working with you, obviously, next session, to at least see this through. Yes, I agree with you. I'd love to end them all together, because it is astounding how much debt the cities and counties and ISDs have. And Representative Israel, if you're looking for more money for your ISD, I recommend you go up to Allen or McKinney and talk to them, because they're too busy building a new $60 million and $70 million stadium, respectively, for their high school football games.
They've already spent it.
Yeah. So I mean, that's it. And like you said, in that bond election, if I read this correctly, it was one of multiple things, and the $220 million bond package included the 12,000-seat stadium. For a stadium they're going to play, 6 or 7 or 8 home games a year. So
Well, they'll have graduation there.
okay, they'll have graduation
Well,
there.
I have
Eight
to
events.
say, I did graduate from Odessa Permian, so I'm all about Friday Night Lights, but it really is outrageous when we see U.S. News and national media, Forbes and others, talking about the cost of stadiums in Texas, when we are focused on certainly a growing student population, and we want to be putting more of our education dollars in the classroom, and seem to be so focused on football stadiums. But I think there's a lot that we can do to improve the situation.
We had simple bleachers in my high school, and it did just fine.
I put my purse down, it'd fall in between the
Right.
wooden bleachers, yes, sir. But, well, let me say, Odessa Permian won a lot of games back then with those bleachers. We don't have those anymore either.
I know.
Well, thank
I
you
think the
again.
Savannah Bobcats were the winningest 3A team until they built their new stadium.
That says a lot. I might just add one thing. Whenever I travel, I always visit schools and look at their stadiums. I was in Pensacola this summer on vacation, and they have a smart school program there, which I've been an advocate of for quite some time, and they've built a number of schools under this smart school program. And I saw their stadium, and it was their high school stadium that served 4 high schools, and it would not have been a junior high stadium here in Texas. So it really does put things in perspective for us. Thank you so much.
Thank you.
Thank you. Did someone else?
Yes,
Rep. Schofield.
Ms. Venable, I thank you for constantly bringing attention to this. Our voters predominantly see us as a low-debt state, and they think because at the state level we are, I don't think very many of our people understand the weight of debt we carry at the local level. Right. And I think in particular the fact that we seem to go to debt first. And I'll give a little shine to my own district. The city of Katy set aside money for a city hall over several years and went to the citizens and said, what would you like it to look like? And when they opened their city hall this June, they owned it free and clear. Not one penny of debt, which means you're not paying interest over this over the years. I had a bill last session that didn't go to this committee, but I could not get it out of committee just simply to say that the items that a governmental entity put in its bond should outlive the debt. You have schools putting computers that are going to last 5 years under a 30-year bond, and there is no way you can justify that as fiscally prudent.
You're so right. If I might just add, there was a time when DISD was paying storage for computers, and someone came to me to share this information with me, and on further inspection we saw that they had bought those computers in a bond and couldn't get rid of them because the bond wasn't paid off, even though they had bought new computers, so they were having to pay for storage of those computers. It's it really is insane, and thank you for bringing that up.
Thank you.
Madam Chair, members, thank you for having me. My name is James Quintero. I'm the Director of the Center for Local Governance. I want to, again, thank the committee for tackling this charge, because I think it's these kinds of process reforms that can really help us to get on a better footing when it comes to our fiscal environment. Now, as Peggy mentioned, we have in Texas about $339 billion worth of total local debt. Now, I like to use the Bond Review Board's local debt outstanding figure, which refers to the principal amount only, if for just one reason, and that allows for a comparison among our peer states. Now, what BRB's 2015 annual financial report found is that compared to the top 10 mega states That $225 billion in local debt ranks as the second highest in a per capita comparison. We have about $8,350 owed for every man, woman, and child in the state. Now, only New York has a greater burden with $10,000 plus owed by their local governmental entities. And across all of those mega states, what you see is an average burden of about $6,000. So we have a lot of local debt in Texas. Now, it's not just that we have a lot, it's also that it's growing very quickly. When you look from 2000 to 2015, what you see is that the growth of local debt has accelerated by more than 160% over that period. You track population and inflation over the same time frame, you see that it has grown by less than 70%. So based on that comparison, I can say that debt is growing faster than population and inflation at a rate of more than 2 to 1. That is not putting us in a good fiscal position. Now, there are, of course, consequences to allowing the situation to persist. We, of course, see at the local level things like higher taxes, fewer services, lower credit ratings, or some combination of both. There are consequences for allowing this situation to develop. And what's unfortunate is that it has developed oftentimes in an environment where people aren't expecting what's happened. And to substantiate that point, I want to refer you to a 2014 article from the Austin American-Statesman where a reporter goes out there to one of the community meetings and speaks with a number of different people about a tax issue that's being discussed. And she interviews several different individuals, but one person's testimony in particular stood out, and that's Gretchen Gardner. Now, what Gretchen had to say I thought was very illuminating, and here it is. Here's the exact quote. She says, "I'm at the breaking point," said Gretchen Gardner, an Austin artist who bought a 1930s bungalow in the Bolden neighborhood just south of downtown in 1991, and has watched her property tax bill soar to $8,500 a year. "It's not because I don't like paying taxes," said Gardner. "I have voted for every park, every library, all the school improvements, for light rail, for anything that will make this city better. But now I can't afford to live here anymore." Now, what's tragic about Gretchen is not that she's necessarily paying $8,500 a year, which, interestingly enough, comes to about 2 car payments owed per month. That's not the real tragedy. What's the real tragedy is that this situation has emerged at her own doing. What Gretchen has done is voted for all of these different improvements that will make the city better, but has done so not knowing the tax implications of her decision. And so now she's being forced to move. Now, that's not to say that Gretchen doesn't bear some responsibility in this scenario, but I think government is not blameless either. Government has ownership of a system that provides too little information to voters at the point of decision making. When a voter steps into the ballot box to say yes or no to a proposition, they are provided with 2 pieces of information. They're provided with the principal amount that's being decided on, and a short description of legalese that can usually be twisted and construed to mean anything. And I've seen it happen time and time again. That is not enough information. Now, what's interesting is that the propositions being put forth to voters are not just confusing to Gretchen, but also to folks up in North Texas. And I have a lot of friends up in North Texas, and one of the things they told me is that this McKinney ISD bond proposal was very confusing on a number of fronts. And I want to read it to you very quickly. It's a short proposition, but here's what was put before voters. It says, "The issuance of bonds in the amount of $220 million for the construction, renovation, acquisition, and equipment of school buildings and the purchase of necessary sites for school buildings, and the levying of tax in payment thereof." Now, that put before voters may satisfy certain legal requirements, but it does nothing to tell people what the actual cost of issuing those $220 million in bonds is, what is the estimated total repayment that's being taken on, nor does it tell people what the tax implications are, especially in a high tax area, nor does it tell you that of that $220 million, $50 million is slated to help facilitate the purchase of a new stadium, to be supplemented with $20 million in additional unused bond proceeds. So, again, I say that this information provides an incomplete set of data points to voters, which I think is helping to perpetuate a very bad fiscal situation. So what is our solution? So I think I want to put three solutions before the committee today. The first, which I know was not well received by my colleagues, but I still think it is probably one of the most important reforms that I'll work on this session, and that's to improve ballot box transparency. Now, again, only two things go before voters right now: the principal amount to be borrowed and a general description of the purpose. What I think needs to be supplemented is the addition of two items of information. One is, what is the estimated tax impact on the area homeowner? How much is that person's tax bill going to rise if that proposition passes? And I think that's very important. I find it to be very common sense to know what your tax bill is going to look like if a debt is assumed. I mean, no one would go and purchase a car without knowing how much their monthly payment is going to be. And then the second piece of information that is very important is the estimated total repayment cost. What is the principal and the interest payment at the end of the day? And why that is important is because school districts in particular have been abusing a public financing instrument known as capital appreciation bonds. This allows you to issue a bond and effectively circumvent the 50-cent debt limit, issue a bond for very little in terms of principal, but then when the total repayment is due, sometimes in 40 years, the interest side of the equation can add to the total cost so that what was initially taken out ultimately becomes 10 times as much as originally borrowed. So it's important that voters have a more complete understanding of the debt that's being issued.
When did the CAD start becoming standard, or when did they start using cabs?
So cabs have been around for a while, and interestingly, California has moved to impose severe limitations on their issuance. Michigan has banned them outright. Then, of course, during the last legislative session, I think we took some good steps in the right direction to curb their use. But you see, and this is an issue that is particularly potent at the school district level, and again, they're using them to circumvent the 50-cent debt limit. And so as a lot of schools have started to get closer and closer to that INS limit, then these are being issued so that, they have the money that, they need to issue whatever debt they're seeking, and do so in compliance with existing law. What's interesting about this ballot box transparency idea is, I think it was Mr. Longley, he said that, voters have enough information. We have, there's really no need for this additional detail. But I think voters in the city of Dallas proved him wrong in this aspect. In November 2014, a proposition was put forward by the Dallas City Council, and I believe it was championed by Councilmember Scott Griggs, that basically would have accomplished some of what we're seeking here. And the proposition, which I won't read to you, you're welcome to see it at the bottom of page 3. But basically, one of the things that they asked voters to approve is additional disclosure for bond programs. And one of the items included in that proposition is the estimated amount of repayment, including principal and interest, based on current market conditions. Now, and almost 90% of voters who decided on that proposition said yes. Clearly, there is an appetite for more information at the point of decision making, because people want to feel like they're armed with at least enough information to make an intelligent decision about the fiscal direction of their community, especially given the tax and debt problems we have. And so I think this reform is not only critical but desired. The second reform that I think would help, and as Peggy spoke to already, is to institute a requirement that if a capital project exceeds a certain threshold, then it ought to be required to be included on a separate proposition. Too often what we're seeing is that political subdivisions who are seeking bond issuances are mixing a little bit of want with a lot of need. And so, again, I point back to McKinney ISD, who perhaps, because of a lot of growth, maybe needed some infrastructure improvements, but then they also included $50 million worth of a new stadium. I think voters ought to have a very clear choice.
Actually, I think it's 70.
So it is 70. So they used, I believe it was $13 million in unused bond proceeds from a 2000 bond issuance, coupled with $4 million in extra money they found.
That's just what I've read.
Yes, the number is astronomical, and so I think it would really help our situation if we required political subdivisions to put forward some of these big ticket items in a straightforward way.
Madam Chair?
But Schofield.
Correct me if I'm wrong. You've obviously studied the law on this more than I have. There doesn't seem to be any requirement in the law that if you say your $100 million bond is going to have $30 million for this and $40 million for that and $20 million for the other, that you actually spend the money on those. You could spend $99 million of it on the first item if you wanted to. Is that? Wow. We don't have, as far as I know, there's no. If you tell people that 17 million of it is going to be for this high school, and you're going to build an aquatic center with only $5 million, you could spend almost the entire thing on the aquatic center. Mm-hmm. Is that correct or not?
To my knowledge, there are no statutory requirements to that effect. And what you would perhaps hear from the other side is that, some of these estimates they need flexibility in some of these estimates because of the cost of construction may go up in one area, and so they can shift funds as needed. But I think that
it seems like if we give them a certain leeway, like 5% or something, if you ask for $30 million for an aquatic center and it ends up costing 55, maybe you should have to go back to the voters and say, you approved 30, we need another 25 million, and see if they go for it.
Mm-hmm. I would agree. I think that I think there's a lot of work to be done in this area.
Madam Chair.
Vice Chair.
Yeah, just to clarify, James, my understanding is $12.5 million from a 2000 bond. From 2000 will roll over into the new stadium.
And which, I have some concerns about unused bond proceeds too, and I think Representative Larson put forward a bill last session that was targeted specifically at municipalities, but in my opinion probably could have been targeted at everyone at the local level. There is no such thing as leftover bond money. It all belongs to the taxpayer, and if it goes unused, it ought not sit dormant somewhere, waiting for some opportunistic person to find a use for it. So I think that is also a contributing factor in our current fiscal environment.
Madam Chair, I've been thinking about that since Mrs. Venable said it, and I always try to look for the unintended consequences. And my concern is, if you say, well, you can't have leftover bond money, they're going to act like most government entities and go, we've got to spend all this. So if we promised $35 million for the high school and it came in at 27, well, we've got to find a way to spend another $8 million on this thing.
Some unintended consequences. How do you balance it?
How can you make them be fiscally responsible and spend only the money that they need and turn the rest back in? Otherwise, you end up with gold-plated toilets in the restrooms. Or certainly one heck of a principal's office.
In the football stadium.
And then the last issue I want to touch on is this issue of rolling polling. This is one that we We worked on, I thought, to some success during the last legislative session, but during this interim, it seems to have gone sour. And I'm not a lawyer. I'm a numbers guy. I like numbers, facts, data. So I don't understand all of the legal analysis behind the TRO, which was sought against Highland Park ISD, seeking to enforce the provisions of HB 2027, which related to curbing some of these rolling polling practices. But the court found against our conservative, like-minded friends, and so it's my understanding that as of right now, there's still a lot of work to be done to curb this practice.
Well, it seems like they got around it by saying they did not have an established early voting place. See, if they didn't have the early voting place established, then they could do rolling polling. And that was a floor amendment that was added.
Yeah, I'm very concerned with this practice. It's the foundation's position that it should be eliminated entirely.
I think that totally watered the bill down. I think that was sort of the silver bullet that killed the whole intent of the bill.
Yeah, so we're hopeful to work with the committee during the next session to see that this reform is strengthened. That
my office got more phone calls on that one, I think, than we've gotten on a lot of stuff.
And again, I think it's a contributing factor in the overall debt problem, especially when you take into account the fact that school districts have the greatest amount of debt. This is perhaps, one of those small contributions to that point. And I believe someone mentioned consolidating bond elections in a November timeframe. That's something that, while we have not done a lot of research yet, we are in favor of that proposal. I think that when you put forward these big bonds to be decided upon by a very few in the community, I think there's a better way, especially when the November time frame allows for a greater number of people to participate in something that's going to affect everyone in the community. So, and with that, I want to thank the committee.
Any questions, members? Thank you guys for being here.
Thank you.
Really
Thank you
appreciate
very
it.
much for inviting me.
Thank you. All right, now we will move on to our last charge, and that basically deals with the oversight of the agency that we have jurisdiction over, Secretary of State. And Keith, come on down. You're on. And I know there are some questions for you, but I'll let you begin.
Certainly. Thank you, Madam Chair, Committee. Keith Ingram, here representing the Division of Elections in the Secretary of State's office. And I would like to start out by saying that we take as our mission to be technical support for Texas elections, for the voters, for election officials across the state. The election code in 31003 says that our job is to obtain and maintain uniformity in the interpretation, application, and operation of the election code and election laws outside of the election code for the state of Texas. We have, right now, 27 people in my division. The state of Texas is extremely large, 254 counties, you heard 1,200 cities, about 1,800 or so school districts, plus numerous emergency service districts, water districts, boll weevil eradication districts, all kinds of districts holding elections. And so we have a 1-800 number that is mandated by statute for the public, and we have a 1-800 number for election officials across the state. And we take calls every day, all day. The call volume, obviously, in a presidential election year, gets to be quite large. We're on the verge of hiring 2 temps just to answer the phone and do voter registration application opening and sorting. So it's an extremely busy time in our office. We want to be as transparent, responsive as we can possibly be, and we look forward to working with y'all. Obviously, we would never take the position that we've arrived and have nothing upon which to improve. So we are welcome to any of your questions or suggestions.
Well, I think one of the charges is, how are local election officials informed about the changes to the election law? What are you guys doing on that?
Absolutely.
And is there anything we can do to improve on that?
There is certainly room for improvement in that area. That was the testimony that we heard yesterday about
and I think
local
there's a
election
lot
officials.
of confusion going on there.
That a persistent concern that I have is the local election officials in the very small counties. And the reason that I have that concern is because they do not have any budget available to come to Austin for our seminar. It used to be, back before 2011, that we had the personnel in our office. We used to have more than 40 folks and the budget so that we would go around the state and do regional trainings. I would very much like to start that again, even if we can fit a one-day seminar in the Panhandle, a one-day seminar out in Southwest Texas. If we could do something like that once in a while to help with the communication in the smaller counties that can't make it to our seminar here in Austin. We believe that the materials that we put out are useful. The problem is that we have such a high volume of words that it is difficult for someone, especially if they're a sheriff or a tax assessor collector with other duties, and voter registration is just one more thing in their portfolio, for them to pay attention to what we put out. So we have taken great pains since I've been in this position to rearrange our email communications so that we put it in more bullet points and less prose, and then we can give the detail later, but we want to make sure that they get the headline news and then see what they have to focus on. So we've made a concerted effort to make our communications more, I want to say, terse, succinct, so that we can actually get the stuff read. That's one thing we've done. What we've also done is, especially in the voter registration section, is we do monthly webinars, and we stopped that while we were doing the redevelopment of the team project, but it's started back again now. And the voter registration section in my division will put out a manual for a particular task in voter registration, deceased cleanup or whatever it is. And then they will have a webinar that month on that topic, so that anybody can. So it's 20 or 25 participants per webinar. We'll do 4 of them in a month, and train officials on one piece of the voter registration database system. And so we've started that back again. I think that's a good program. It's not as good as going in person, but it is a way to reach people that technology affords us. But yeah, there's a lot of room for improvement in communication with the county election officials, and I would like to start regional training as the first step in that.
Israel.
Mr. Ingram, do you have any other things to say before I have a few questions?
I'm at your disposal.
Good.
Should I have the other members ask their questions?
That pleases me. I have a few questions because there was a big event happen in that the federal courts struck down our strict photo ID requirements, and that was in July. And I was wondering if you could advise me. I have a couple of questions pre-order, and because I'm concerned about whether or not you're capturing this information. Can you advise me on how your office is keeping track of those folks who were unable to vote due to a strict photo ID and voter ID?
We didn't keep any records. We didn't collect the provisional ballots related to ID. I did talk to county election officials to see, what are some things that you're seeing, and it was very much the case that the number of provisional ballots due to a lack of photo identification were the smallest part of the provisional ballot number. So there were a lot more provisional ballots for other reasons than there were for ID. As far as what we do, we take obviously calls on our 1-800 number, and we get them especially on election day. And so we would hear recurring themes. The themes that we heard were that there were 2 groups that there weren't a lot of calls, but there were some. And it was related to these two kinds of groups. One was senior citizens who have used an expired driver's license for most of the things that they need an ID for, and they couldn't use it to vote in person. So we had senior citizens without an ID, and then we had folks who moved here from other states, either as a student or a permanent resident, who had an out-of-state driver's license but not a Texas driver's license. So those are the two groups that we heard from primarily.
Okay, so you have anecdotal evidence only, but if I asked you how many Texans submitted provisional ballots, you wouldn't know?
I have no idea.
Could you find out, or is that not possible?
That would be something that the counties would have. I don't know if...
We'd have to ask the counties to collect it and give us some information.
Right.
Okay. Now, post-ruling, for the sake of those who are watching, and we all know now, a photo ID is no longer required to cast a vote in the state of Texas.
That is not correct. Photo ID is still required to cast a vote in Texas, unless a person does not possess an acceptable form of photo identification and has a reasonable impediment to obtaining such a photo identification. So photo ID is still required. That's what we call the List A. So the 7 forms of acceptable photo identification, if you have one of those, you have to use it to vote. That is the law. However, if you do not possess one of those forms of ID and you have a reasonable impediment to obtaining one of those forms of ID, then you can show an alternate form of ID and do a reasonable impediment declaration under the penalty of perjury.
But we're back to what we had before the Senate bill requiring a photo ID, and that is, if I've got a voter registration card, I can go vote.
Not if you have a driver's license. If you have a driver's license, you have to vote with your driver's license, or a military ID, or a passport, or a citizenship certificate with a picture on it, or a concealed carry license.
So I can vote with a paycheck?
If you do not have an acceptable form of ID, if you do not possess an acceptable form of ID and cannot reasonably obtain one, then you can vote with alternate forms of identification. Yes, ma'am.
But you have to have a signed affidavit with that.
That's right, a reasonable
And
impediment.
the affidavit is with the election judge?
Yes. Yeah, and then you vote a regular ballot.
Right. That was a compromise worked out between the AG and the courts.
So
Right.
when the court just issued, looks like September the 20th, sort of sent an order. It wasn't a nice memo. It was a court order saying that we had to revise the information that we were giving to the public. Why don't you set up for us before order and post order and what you're doing?
Sure. So in our materials that we developed after the August 10th interim order on the compromise, in our materials we said if you have not obtained and have a reasonable impediment to obtaining one of the official forms of photo identification, then you can sign the reasonable impediment declaration and go forward with an alternate form of ID. The court wanted to know from us why we didn't say the words possess and cannot reasonably obtain instead of has not obtained and cannot and has a reasonable impediment to obtaining. She agreed that our materials are not misleading, and she agreed that we didn't have to go back and retroactively change anything, but going forward she preferred that we use her language, possess and cannot reasonably obtain. So that's the language we're using going forward.
So the affidavit process, could you walk me through what the affidavit process is now?
With the reasonable impediment declaration, sure. So the poll worker will ask a person to present an acceptable form of ID. They'll say they don't have one. Well, do you have a reasonable impediment to obtaining one? Yes, I do. Do you have an alternate form of identification, a utility bill, bank statement, anything with your name and address on it? There's a list, but not anything with your name and address on it, but anything on that list or other government document. And an other government document can be a driver's license from out of state because it obviously has the name and address on it and it's issued by a government. And so the address that's on the other government document doesn't have to match. The voter will then sign a reasonable impediment declaration. They will put on the reasonable impediment declaration their reasonable impediment to obtaining photo ID, lack of transportation, lack of funds, lack of supporting documentation. There are several reasons on the form. And then they will vote a regular ballot. The election judge on the reasonable impediment declaration will note what form of alternate ID was shown and will sign it.
Okay. Now, that can get very confusing on a very busy election day.
Indeed.
So, how are y'all going to get that word out?
We have already started that process. We put out an advisory, obviously, and we put out a PowerPoint that is the whole voter ID process, qualifying voters with the identification process, revised to include this new procedure. We've also modified our qualifying voters handbook and our online poll worker training so that poll workers are being trained on the new procedure across the state with the new materials.
Now, have y'all thought about getting that information to, in some of these small counties, they may not even have a Democrat chairman, party chairman, or Republican party chairman, but a lot of times those party county chairmen are sort of the first line on recruiting poll workers.
Absolutely. Part of our education program is to get toolkits with press release, with the instructions, with the whole procedure outlined to as many folks as possible. So those are available for community groups, those are available for local election officials, and those are available for local party chairs. We want to get that information into as many hands as possible.
Can
yes,
you
ma'am.
give us a copy of what
Sure.
y'all are putting together?
You bet.
Yeah. If you get it to my office, we'll get it to the other office.
Absolutely.
How much is that costing the Secretary of State's office, this public service campaign that we're doing?
The amount left from the appropriation was $2.5 million, and that's how much we're spending.
Are we spending it through outsourcing it, or are we spending it through your 20-odd employees who are doing an extra layer of work?
My division does not do anything other than with regard to election officials and answer questions on the phone. So we're doing our part with existing resources. We have a communications division that is responsible for this work, as well as the Secretary of State who's out traveling around. So the bulk of it is going through the outside vendor, but we are doing some of it in-house with the Secretary's visits around the state.
And I wasn't clear on the outside vendor part. Who is your outside vendor?
Burson Marsteller.
And how much is their contract for?
I don't know. Because it's the whole year. It's not just, they don't have a contract for this November. We did a contract last November, December for the whole year.
So there was no adjustment to their contract based on the work that we're doing right now?
No, because whenever we did the request for proposal last year for this year's election, that was built into it, that we were awaiting a court order. We didn't know which way they would have to go, and so they had to be ready to jump either way or do whatever they needed to do.
Okay.
That was part of the requirements.
Who oversees Burson Marsteller?
Our communications division and the secretary.
And how much interaction do you have with them?
Very little.
So what are your expectations?
So I'm the subject matter expert. I would never tell them how to do a media campaign, but when they want to know if their message is working or is the right message legally, then I definitely have something to say about that.
But I would think as the elections guy, you would have expectations that they would do a good job.
Certainly.
Do you have any expectations on how many people they would reach? Is there a measurable there?
Yes, they do something that they call impressions, and after the media campaign, we'll get a report on how many impressions they had digitally as well as in radio and TV.
Yeah. So it's an electronic focus, an online focus.
I wouldn't say that. No, the toolkits are part of it. The Project Vote with the high school students is part of it. But obviously the bulk of the money is going to be spent electronically.
So do you think you're already in compliance with the order that was issued, or are you in the process of being in compliance with the order that was issued?
The September 20th order?
Yeah.
I believe we're in compliance. I think, the stuff that we needed to correct immediately, there were 3 things that we needed to correct immediately, and that was the front page of Vote Texas had a banner that said cannot obtain, and she wanted us to put the word reasonably in there. There was a press release that was linked at the bottom of the Vote Texas webpage that said cannot obtain, and she wanted us to put the word reasonably in there. And the voter identification posters for the polling place, she wanted us to change the language there from have not obtained or do not. Anyway, I don't remember what the old language was, but to change it to do not possess and cannot reasonably obtain, and we have done that. That went out last night.
Okay. So one more thing, back to where I started my questions with you about the provisional ballots that did not count before and that would count now. Do you have an estimate on how many provisional on what those provisional ballots were? I know it's a presidential year, so that voters are highly tuned to voting this year, but
So I don't know, because we've had how many? We had November of 13, May of 2014, March of 2014, primary runoff, May of, and so then we had November. We've had 2 Senate special elections. We've had I don't know how many tax ratification elections. So I just don't know. And then we've had this primary and primary runoff and a May election this year. We've had a November constitutional in 15. So we've had a lot of elections. And I have no earthly idea how many provisional ballots have been cast for voter ID. I know it's a pretty small number, but I don't know. We haven't had the turnout that we expect for this election yet.
yeah, this is our first presidential.
Exactly.
So if no one is, for those who didn't, if they signed an affidavit, it's not considered a provisional ballot. To vote with an affidavit is not a provisional vote.
So you're talking about for this upcoming election with the reasonable impediment
Yeah.
declaration? No, they'll vote a regular ballot.
It's not considered a provisional.
It will not be a provisional ballot.
Okay. All right. I think that's covers my.
Vice Chair? Oh.
Okay, thank you. Keith, how do y'all get the word out? Because I was in a discussion with someone just last night, and we were unclear. So how do you get the word out to the people of Texas, to your elections administrators, more importantly, to the election judges? Because I can see there be major confusion over whether someone needs an ID or not.
Now you see why I don't sleep much these days. No, that is exactly the biggest hurdle that we have, because we can send out the materials, but we can't make them get read. And we can send out the updated qualifying voters handbook, but we're not there to help train those election judges. So some counties will do it very well.
Will y'all send out a press release and let the
We have. And, it makes as much of a splash as it makes.
Is it posted on the front of your website?
It is. It is.
Oh, what happens on the signed affidavits? Yeah, it's a real ballot. They're voting. It goes in private.
We have asked for the counties to send copies of those to us so that we have an idea about what sort of populations and what sort of reasons people have, and so that we will be able to answer a question like this in the future.
Exactly. I was thinking on the provisional, I think this will be very key.
Yeah, and so we've asked for counties to send those copies of those. And for the tax ratification elections that have already been held, we've got, I think, 12 or 15 of them from those elections already.
Madam Chair?
Oh, that's you're next.
Will you also be collecting data on how many people submit these declarations who actually already have a valid form of ID?
I don't know if we will be able to make that determination. From the ones that we've seen in the tax ratification elections so far, there's going to be some that we'll be able to tell on their face that they have a photo ID.
Because I would like that information.
One of them for a TRE said left it at home. That was the reasonable impediment.
Yeah, and what I don't want to see is a gross number, and everybody acts as if those people don't have ID. I want to clarify, I want to make sure everybody understands what you said earlier. If you have one of the 6 valid forms of photo ID issued to you, photo ID is still in effect. You are required to show it to vote. If you pretend you don't have it and use one of these declarations, that's illegal, isn't it? I mean, you are required to show it.
It is not, a reasonable impediment declaration is not a convenience document. It is to help the voters who do not have an acceptable form of ID. I will say that the August 10th interim order changed the acceptable form of ID expiration date, so you can have one that's expired up to 4 years now instead of 60 days like SB 14 required. So you can have a driver's license that expired less than 4 years ago and use it. And if you have one, you have to use it.
So an expired or valid or currently ID, a passport, a military ID card, the feds still don't issue citizenship papers with pictures, but if they ever do, a handgun license, any of the things that are in the law, if one of those has been issued to you, you are required to show it to vote. It is only for those people who don't have one and can't reasonably obtain one who are allowed to use this declaration, correct?
I would disagree with you a little bit because you said issued. Some folks have had them issued, but they have been destroyed or lost, and they have a reasonable impediment to getting a new one. So if they don't possess one, and that's the operative word, and can't reasonably obtain it.
Students who are here from out of state still must have a Texas ID, or can they use their ID from another state?
They can use whatever driver's license or ID they have from wherever they come from.
Thank you.
Madam Chair?
Oh, I'm sorry, yes.
Sure. Hey, okay, Keith, I know you guys have been inundated because I read where the number of voter registrations is significantly up and we're about to hit a record number, correct?
We have hit a record number already, and it's only a question of how big the record will be by the time October 11th gets here. If y'all know somebody that is not registered to vote, now is the time. October 11th is the deadline.
Yes, I do.
So my question regarding the reasonable impediment, we're not expecting the election judges to be referees or arbitrators of that, right?
As a matter of fact, they are not allowed to be
that's
a
what I thought.
referee or
Right.
arbitrator of that.
So basically, it's a good faith assertion when the person says that declaration that, hey, there's a reasonable impediment. They can't be questioned.
Right. They cannot be questioned about what they say is the reasonable impediment. That is true.
Okay, so basically that person, that voter, they say, hey, I don't have the acceptable form of ID. The person asks them, did you have a reasonable impediment? They say yes. There's a form for them to fill out, sign it, and then they get a ballot.
Well, they have to show
an alternate form of ID.
Yeah, that's what I mean. Yeah, but
if they have no ID,
Right.
nothing, and they don't have a paycheck or utility bill, then they would vote provisionally.
That's right.
then got it. Yeah.
Okay.
But yeah, if they have their voter registration certificate and they do not possess one of the acceptable forms of ID, then they could use the VR certificate to vote with.
Right. Okay. And I understand that they could bring a utility bill, or there's other exceptions as well, correct?
That's right. I don't have the list memorized, but there is a list.
Okay.
There's a list.
Thank you.
It's a utility bill, paycheck, government document with the voter's name and address, expired driver's license if they are less than 4 years past.
Right.
Yeah.
I'm sure. A follow-up to what Keith just said. So if somebody votes, they show up with their voter registration card, which I think most people are used to. They have to fill out a provisional. I mean, not a provisional. I keep calling it provisional. An affidavit.
Well, if they possess one of the acceptable forms of ID, a VR certificate will not get them a ballot. If they possess one of the acceptable forms of ID but just left it at home or it's in the car or whatever, then they have to. Sorry about that. Then they have to vote provisionally and come back and cure within 6 days after the election.
But just most people I know are gonna, if they're told, just go take your voter registration card and we need you to go vote, which is what a lot of us are doing.
That shouldn't be the message. It shouldn't be the message that you should take your VR certificate to go vote.
What is the Secretary of State's office telling the voters of Texas right now
To
to eliminate this confusion?
Right, and I'm afraid the confusion is inevitable, but what we are telling people is photo ID is required to vote. If you do not possess an acceptable form of photo ID and cannot reasonably obtain one, then you can sign a reasonable impediment declaration and show an alternate form of ID.
How many, in terms of the process, we're going to have long lines again, just because it's the way it is. Can you lay out a scenario on the steps that are going to happen for our precinct judges? On that day, there's a line of things that have to happen.
Right.
You match it up to the record.
You mean the election judge?
Yeah, I'm sorry, the election judges. What's that day going to look like? I mean, I guess I'm worried about really, really long lines.
I'm worried that they don't have the education.
Because they just brought their voter registration card. So what are the steps that a precinct judge is going to be doing?
Election judges.
Election judges, sorry.
Well, a lot of them, if they have a voter ID.
So for most people, it's going to be a non-issue. They'll show their driver's license. They'll get checked in like a normal person. I was wondering if you could pull up the qualifying voters handbook on the.
Yeah, but one confused voter and it's going to hold up the line and then you've got confused judges.
But if they have a voter
I mean, that's the
card,
case
chances are
now.
they're going to be online anyway.
So that's not going to be different, and I do not think that this necessarily introduces a great deal of additional amount of that. There is always a confusion whenever a voter shows up. They expect to be on the list of registered voters. They're not. So then that has to be looked up and see what precinct they're supposed to be in. They can be directed to their correct precinct, or they can vote a provisional ballot in the precinct that they're in. But there's always that sort of confrontation that occurs occasionally on election day. And so this is going to be another opportunity for that. But I don't think that necessarily we can expect that it's going to be a huge problem. I wouldn't expect that. I think that on the margin it might introduce a little bit extra, but not any significant amount more than.
Well, I'm thinking of like at a checkout line at a grocery store. You know, if you've got 20 people in line and 10 of them have a card and are swiping, it goes faster. But if the other 10 are slowing things down because they're pulling out their change, it takes more time. And that causes more backlog, and the lines concern me on.
That's why we have 2 weeks of early voting.
And especially we've got a lot of people voting on that one weekend of early voting, and then a lot of people just wait till election day. They're traditionalists.
Here's what our qualifying voters handbook says. It says, ask the voter to provide an acceptable form of photo identification or permanent disability exemption. So the election officer is supposed to ask the voter to present an acceptable form of ID. Acceptable forms of ID are as follows. Updated procedure. Prior law required it to be 60 days. Now it's 4 years. If the voter states they have obtained an acceptable form of ID, but they did not bring it to the polling place, the election officer should explain that the voter can take one of two actions. They can leave the polling place and return with the acceptable form of photo ID, or they can cast a provisional ballot and cure by appearing at the county voter registrar's office within 6 days after the election.
Say that again, I didn't hear you.
So if a voter indicates to the poll worker, oh, stink, I left my driver's license at home, then it's the same process that it was with SB 14 unmodified. You give the voter two choices. You can go home and get your driver's license and come back, or you can vote a provisional ballot and cure within 6 days after the election. So that's unchanged. The new change is here. If a voter indicates that the voter has not been able to obtain an acceptable form of photo ID, the election officer will need to follow the guidelines below. If they haven't obtained an acceptable form of ID, the poll worker should ask the voter if they have a reasonable impediment or difficulty to obtaining an acceptable form, and if they have a reasonable impediment to obtaining it, then they need to execute a reasonable impediment declaration and show supporting documentation. So this is the new wrinkle.
And at this point, if the reasonable impediment is, I'm in South Austin and I left my ID in North Austin, you write that down and that vote counts.
If you show a supporting document.
How do you show a supporting document, like a utility bill?
Right, valid registration certificate, birth certificate.
Can I follow up on that? Is that correct? She said if you're in South Austin and you left it in North Austin but have it, you're going to let them vote with a reasonable impediment?
The poll worker cannot challenge the reasonable impediment asserted by the voter.
So if he says I left it at home?
Yeah, but they're saying they have an ID.
Yeah, he's saying I have it, but I left it at home. That's not having
That's already
one.
covered up here.
Well, that was my question. She said you're in South Austin, but you have it in North Austin.
If you have a voter who indicates that they've got a driver's license in South
Happens
Austin,
to me all the time.
But you see, the problem is that we've already had that conversation with the voter. And the voter didn't say anything about that, and now we're at this point where they put on the reasonable impediment declaration, left it at home, like one of the TREs that we've got. And if that's the reasonable impediment, then I think that voter is at risk because they're not following the law. But that's not for the poll worker to decide. The poll worker is supposed to allow that person.
So how does that get challenged, and then how does their vote null and void?
The vote will never be null and void. It'll get challenged in an election contest if it's a close election. And obviously these things will be available for folks to give to their district attorneys to follow up with.
I realize we're going to have a lot of illegal votes and a lot of fraudulent votes. That's why we had voter ID, and people are going to work around it. My concern is there are going to be a lot of people trying to thwart the law, but who have valid driver's licenses, who have passports, and are going to assert these declarations. Their vote may count in this election, but I want to make sure that when we go back to court, we're not saying, oh, there was this huge number of people that filed these declarations. I want to drill down and find out which one of them were bogus.
And I think you'll be able to tell easily. One of the reasonable impediment declarations that we've already seen had in the reason for other fascist law.
Yeah.
So,
and then one thing, and it's
so I think it's not
times.
going to be a secret, is what I'm saying.
Wait, what did you just say?
That one of the reasons given for
She
the
didn't say
reasonable
fascist.
impediment is fascist law.
Seriously.
Seriously.
Now, again, just to clarify, you've said it, I think, at least twice, but I want to make sure we get this out. We should not be telling our voters, you don't have to show photo ID, just come with your voter registration certificate. That's not the law.
That is not the law, and if you tell that to voters, you're going to be setting them up to fail.
Okay, thank you.
I think, Keith, you answered this, but I'm not sure. You said that we are now in compliance with the order.
With the court's order of September 20th, yes.
And when I look at the order, they said reissue press releases, fix the website, edit your posters and other promoting materials. Digital, the websites have now been changed. The state of Texas is not required to alter training materials that have already been published. So we are in compliance. We've done all of these things already according
Yes,
to the
ma'am.
to
I
the order.
sent the revised posters out last night.
Okay, good. All right.
Any other questions, members? Rep Rose.
Just real briefly, and I guess it's my understanding that this compromise was really kind of struck in an effort to get this fixed for the November election. But ultimately, what I envision is this issue having to be, better crafted for future elections. Wouldn't you agree with that?
I would.
Okay. Thank you.
All right. Thank y'all.
Thank
very
you.
much.
Thank you.
Okay. Is there anything else you'd like to add, Vice Chair?
No, ma'am, I think these were a great chase.
Thank y'all for
Very
being here. Really
educational.
appreciate that. And if there's no further business before us, the House Committee on Elections is now adjourned, subject to the call of the chair. Thank y'all.
You're not calling, right?
Thank-